We are live and recording. May I have the roll call, please?
Broughton? Not present. Buenaventura?
Present.
Chen?
Present.
Cisneros?
Here.
Duran?
Present.
Good?
Present.
Knoll?
Here.
Shelby? Not present. Soel? Not present. Stallings?
Present.
Tony?
Present.
You have a quorum.
Thank you, Madam Secretary. It is a few minutes after 9 o'clock. This is Friday, May 19th, continuation of the Board of Trustees regular meeting. If you were with us yesterday, you will recall that the board convened into closed session. We came out at the end to reconvene and then recess until this morning. We are in open session now. We intend and need to reconvene back into closed session at this time. I will make an announcement that I understand that there may have been a few members of the public who were under the impression that they would be able to offer public comment this morning. I apologize for any confusion. As our agenda materials state, the time for public comment was yesterday morning. We will not be taking public comment today. All the public comment, and there was substantial public comment offered yesterday. I certainly thank folks for doing that again. We have a very packed agenda today, and we will be just moving through. I don't know how long this I can say that the closed session this morning will end sometime between 9:35 and 9:45, and then we'll take up the open session with the Blue Ribbon Commission item first. Okay, with that, trustees, you should have or will receive very shortly a closed session link, and we'll see you in a couple minutes.
And just for the record, Chair Duran, Trustee Soel is here now.
Good morning, Arnie. Good to see you. I announced the closed session items yesterday. Shall I announce them again?
I think you announced the sale of the building item.
I announced all the items.
Morning, Arnie.
Yep, I'm happy to announce them again if you'd like. Okay, let's go into closed session. Thanks, everyone. I announced it just from the script.
You got it? Okay, yeah, because I remember.
We're live.
Okay, good morning and welcome back. We are back in open session. We're going to move right into item 701 on our agenda, which is the request to adopt recommendations from the Blue Ribbon Commission, having returned from public comment and contingent, of course, upon Supreme Court approval. This item is being presented by the chair of the commission and our good friend and former colleague, Joshua Pertula, along with staff Program Director Audrey Ching and Assistant Program Director Amy Nunez. I understand Mr. Pertula's time is limited with us this morning, so we're going to welcome him to the group and ask him to kick us off. Hello.
Good morning. Thank you for the opportunity to address you today. I'm going to begin by giving a little bit of background on the Blue Ribbon Commission. As some of you may know, California Supreme Court adopted the charter for the Joint Supreme Court State Bar Blue Ribbon Commission on the future of the California bar exam on October 26th of 2020. On April 27th, 2021, the California Supreme Court announced the appointment of the members of the Blue Ribbon Commission. And the commission was tasked with developing recommendations for changes to the California bar exam, including the exploration of alternative pathways, additional testing, and tools to ensure minimum competence in the practice of law. Commission conducted a thorough review, taking into account various sources of information, including the California Attorney Practice Analysis, the CAPA Working Group's recommendations, the 2020 National Conference of Bar Examiners Practice Analysis, and studies on the California bar exam that had been conducted by the State Bar. The commission held its first meeting on July 6, 2021, and since convened both in subcommittees and as a full committee 19 times until April of 2023. Each time it was for a full day of deliberation. In February of 2023, the commission met to finalize the draft report and initiate a 30-day public comment period. The commission received significant engagement, over 1,400 comments from 867 individuals during the public comment period. The final report before you today incorporates the changes and adjustments based on the public comments that were received. The commission's work represents a comprehensive and inclusive effort to address the future of the California bar exam and ensure the competence of future legal practitioners. I would like to say And I will at the end also, there was a tremendous amount of time, effort, and work that went into this, deliberations, and a real effort by the members of the commission. I'm going to turn it over to Amy Nunez, who's going to discuss the charter, walk you through some of the findings, recommendations, and then I'll be back with you at the end. Thank you.
Josh,
Thank you,
before
Josh.
we
Yeah.
give Amy the mic, I do want to point out and thank you very much for stepping into the shoes of your predecessor as the chair of that commission, now Supreme Court Justice Patricia Guerrero, who at the time was an appellate court justice. You have certainly continued the fine work that she started, and I thank both of you for bringing this to what I hope is going to be a very successful close.
I appreciate that.
Welcome. Good morning.
Yeah, I appreciate that. I think as the folks on the State Bar Board of Trustees understand, I was asked to assist at the time and said I would love to help, but I had a full plate. And they said, don't worry about it. You'll be vice chair. It won't take all of your time. And within 3 months, that moved to every minute that I could spare on it. So I know we've all done that, and appreciate the comments.
Amy, hello.
Hello, hi everyone. We're going to start with Audrey. I think she's going to discuss.
Amy, it's you on the charter.
Oh, sorry about that. All right. So the Blue Ribbon Commission charter, the Supreme Court directed the Blue Ribbon Commission first to establish whether the bar exam was a correct tool to determine minimum competence for the practice of law. And within that, if the BRC recommended the bar exam, then we needed to, the directive was to develop recommendations as an alternative of potentially California adopting the National Conference Uniform Bar Exam. If the bar exam, if the UBE was not the appropriate measure for minimum competence, then and California should adopt their own exam. The Blue Ribbon Commission was tasked with making recommendations on what the legal topics would be on the bar exam, what skills should be tested, and whether or not there should be supplementary testing. The Supreme Court also wanted recommendations initially on the testing format, specifically whether there should be a remote exam, whether the exam format should remain in person, as well as visiting the passing score.
Thank you, Amy.
Sure.
While the group was meeting in 2021, but before making any recommendations, they established guiding principles and a mission statement for the work. Admission to the State Bar of California, requiring a demonstration of knowledge, skills, and abilities required for entry-level practice of law, or what we would call minimum competence. Also, minimum competence in professional ethics and professional responsibility. Criteria for admission to the State Bar of California should be designed to ensure public protection. Recommendations on an exam or any exam alternative should be evidence-based. Fairness and equity of the exam or any exam alternative should be an important consideration in any recommended approach. Fairness and equity to include, but not to be limited to, cost and modality of how the exam or exam alternative would be delivered. And any recommended examination or exam alternative should minimize disparate performance impacts based on race, gender, ethnicity, or other immutable characteristics. We're going to go a little out of order from how the report is before you. I'm going to talk about the deliberations the group had on a bar exam alternative, and then Amy is going to discuss the recommendations before you on a California developed exam. So as you've heard, part of the charter was to look at whether a traditional bar exam is the correct or only tool to establish entry-level competence to practice law in California. So the group looked at these considerations for a bar exam alternative. Back to the guiding principles, how would you demonstrate minimum competence in a bar exam alternative? How could you ensure consistency across law school types and law office study programs in a bar exam alternative? Again, to the guiding principles, how would fairness and equity considerations be implicated as measured by questions of affordability and access? How could you scale up an alternative pathway in California? And would this pathway be applicable to all candidates seeking licensure, or would there be some kind of limitation or pilot? In order to answer those questions and considerations, the group heard from existing exam alternatives in jurisdictions and in Canada, and exam alternatives under development in Oregon. The Blue Ribbon Commission heard more than once from Deborah Merritt, who is at the Institute for the Advancement of the American Legal System, scholar in bar exam reform, and also working with jurisdictions now that are developing bar exam alternatives, and Joan Howarth, who also works in bar exam reform. We heard from the Daniel Webster Scholars Honors Program. That's a program that's part of the University of New Hampshire Law School, where a select number, about 20 a year, are selected to be part of this program that has a different curriculum with more experiential externships, internships, experiential training as part of the curriculum. And those candidates that are in the Daniel Webster Scholars Honors Program do not take the traditional bar exam after graduation. They go before the Board of Bar Examiners there and have their work product reviewed. We also heard from Wisconsin, and Wisconsin has had diploma privilege since the late 1800s. So the two ABA law schools there, Marquette and the University of Wisconsin, if you have your JD conferred and meet the other requirements, you can be admitted without taking the bar exam. The Blue Ribbon Commission heard from the Oregon Task Force. So part of the disruption with the pandemic in 2020, Oregon had diploma privilege in their state. And part of that, after they looked at the, what happened with the pandemic, they said, well, what is the correct tool? Like we were looking at too, what is the correct tool for a minimum competence to practice law in Oregon? And the task force recommended what they were calling like a three-legged stool. So having the UBE or the next gen, the NCBE's exam, because that's portable and some candidates are always going to want to take that. Having an Oregon experiential pathway, so the ABA law schools in Oregon would have a curriculum very similar to the Daniel Webster Scholars Honor Program that has more experiential coursework, externships, clinics, and then having a third prong of a pathway for out-of-state applicants for supervised practice. And that task force, where it is now in development in Oregon, they've now have some rules out, some draft rules are out now for public comment in that state. The Blue Ribbon Commission heard from several Canadian provinces, Alberta, British Columbia, Ontario, and then an assessment program that several of the Canadian provinces use called the Practice Readiness Education or PREP program. In Canada, the provinces all, in order to be called to the bar, which is the licensure process there, they article for 8 to 12 months, which means they have supervised practice under a licensed attorney as part of their admission. In some of the provinces, there are no exams. Ontario does have exams, the barrister and solicitor exams. Some of the provinces have this PREP program, this Practice Readiness Education program, where they have online coursework. They have in-person workshops, a virtual law firm, and then a capstone project. So distilling all those presentations, the Blue Ribbon Commission looked at three more main components for any bar exam alternative. What happens in law school, supervised practice, and what would the assessment piece look like? So the law school component, including incorporation of doctrinal and experiential education during law school for that necessary exposure to the knowledge, skills, and abilities to establish minimum competence. Supervised practice, so practicing under a licensed attorney, which could occur, some of the hours could occur in law school, or they could all be post-law school. Again, helping to assess minimum competence, not just in the educational environment or through a test, but in real world practice. And then an assessment component. What would assessment look like? Would it be portfolio of work product review? Would it be a capstone project that you turn in and is assessed, or some kind of oral presentations? Would it be exams, mini exams, or something like that Practice Readiness Education program with the Canadian provinces, where you have a whole series of different online modules, in-person workshops, and a virtual law firm? The Blue Ribbon Commission ultimately did not reach a consensus on even exploring a bar exam alternative. You'll see in the report there were several motions proposed. None of them received enough votes to move a recommendation forward. Now to Amy.
Thank you, Audrey. So the Supreme Court revised the scope of the commission's recommendation and requested that the commission explore what a future bar exam would contain, specifically the knowledge areas that should be tested, what skills should be tested, what percentage of the exam should involve knowledge versus skills, that proportion that should be tested. And also, do attorneys from other jurisdictions need to sit for the full exam? So to prepare the BRC on determining what the future of the California bar exam should be, we prepared a significant amount of exam material and presentations. Initially, the BRC meeting centered on orienting the commission on the current state of licensing in California, which involved learning a lot about the content, format of the California bar exam, its dependency on the National Conference of Bar Examiners multi-state bar exam, the impact of the pass rate on diversity in the state, and the changing demographic profiles of exam applicants. The commission spent time at multiple meetings reviewing the California practice analysis and that CAPA group, their recommendations. We looked also at the results of the National Conference of Bar Examiners 2020 practice analysis and their recommendations for the uniform bar exam, the next gen exam, and the results of additional California bar exam studies, such as studies examining the pass rate of various applicant types. We also consulted with psychometricians, scholars in education and licensing. We examined promising practices for building a better bar exam, and also invited the National Conference of Bar Examiners to multiple meetings to explore their exam models and present those to California. So where, next slide, please, where the commission landed, initially, the first recommendation was that California develop its own exam. And in that action also rejected the adoption of the National Conference of Bar Examiners next gen exam. And some of the reasons that, primary reasons that led to this decision is the commission discussed that California would have greater flexibility in policy considerations related to the exam if they did not adopt the next gen. So things such as whether to test remotely or even offer the exam more than twice a year, California would have greater flexibility to make that determination. Also, California specific content is not going to be covered on the next gen exam. And this would include topic areas such as California Code of Civil Procedure, which is more complex and contains more rules and sources of authorities compared to other states. Excuse me, I'm going to sneeze. Also, the California bar exam would allow us to adjust any exam content, and things emphasizing areas that resulted from the CAPA analysis. And at the time, we had not reviewed sample questions from the next gen exam. As a matter of fact, the next gen exam is still under development. Now, as for the recommendations related to the specific knowledge areas on the future bar exam, originally the commission voted to adopt the CAPA recommended exam areas, which would reduce the exam topics that we currently have from 13 to 8 and include the ones that you see here. So from administrative law and procedure, civil procedure, constitutional law, contracts, criminal law and procedure, evidence, real property, and torts. So in April, when the commission convened, we discussed and approved the initial draft report, and it was released for public comment. A significant number of comments were submitted, and they suggested that in this climate, perhaps ethics is not an appropriate subject to remove from the bar exam. So at its meeting in May, the commission voted and discussed, whether a professional responsibility should be added as a topic. And so after public comment, What changed in terms of the exams and topics is as a result of the public comment was we added professional responsibility as a topic. So we have a 9th subject area that will be tested in the future bar exam, or will be recommended to. And also one of the areas that we received questions in is about whether the California exam, we needed to specify whether it would only cover California law. And here we added language to explain that there are certain subject areas where the scope covers federal law, such as in the federal rules of civil procedure and federal rules of evidence are covered on the California bar exam. Next slide, please. As for the skills to be tested on the exam, the Blue Ribbon Commission adopted the recommendations from the CAPA. So these are the skills that will be incorporated or recommended to be incorporated in the future California bar exam. Slide. So the commission also made more recommendations that responded to the court's request. For example, there was a question about the proportion of knowledge versus skills to be tested. Here's some additional recommendations. So in developing the exam, the recommendation was that there should be significantly increased focus on the assessment of skills so that we would de-emphasize the need for memorization in doctrinal law. Also, in terms of the weight between knowledge versus skills, the commission decided to make that determination after the bar exam, the new exam has been developed. It was something very difficult to assess in theory without having seen what the format and content of that exam would look like. Also, the commission further recommended that transparency on the topics and the rules to be tested, including the extent to which candidates are expected to recall topics and rules. Next slide, please. So the BRC also specified that the exam design should be developed by experts and other specialists. And if the Supreme Court adopts that recommendation, that it is developed by the state bar in consultation with these subject matter experts. Lastly, the design should be consistent with the guiding principles that Audrey highlighted earlier. That is that in crafting this exam, it should be fair, equitable, minimize disparate performance, impacts on race, gender, ethnicity, disability, and other immutable characteristics. Now, on the next set of recommendations, the BRC was tasked with making a recommendation on how attorneys from other jurisdictions should be licensed, and specifically whether they have to sit and pass the California bar exam. So the BRC had to consider 2 policies that you see here: reciprocity, which is it's where a jurisdiction allows licensed attorneys the ability to become licensed without requiring an examination. And that policy allows that privilege to jurisdictions that carry the same practice. The other policy is comity, which refers to the practice of granting admission on motion from one jurisdiction to the other, despite the fact that that same privilege is not extended to the state of the incoming applicant. So jurisdictions, the commission originally recommended in regards to this practice, to revise the requirements for licensed and out-of-state attorneys to be admitted in California without sitting for the California bar exam. And that in establishing this requirement, the Supreme Court, wanted, the recommendation was that the Supreme Court should explore the minimum number of years of recent practice in the other state in order to demonstrate whether whether somebody should be admitted. And so embedded within this consideration that the commission had to ponder is what happens with non-ABA law school graduates in this type of model. So what you see before you here is the landscape today. What's being charted is the 2 different models, reciprocity and comity. and also the determination of which states are open to allowing graduates from non-ABA law schools the ability to either be admitted on motion, whether in a reciprocity or a comity model. And so here, the red jurisdictions require that licensed attorneys must have received their JD from an ABA law school and must have reciprocity, meaning that both states have an agreement that they license each other's attorneys without needing to take an exam. The blue jurisdictions also require that attorneys have a JD from an ABA, but reciprocity is not required. They have a comity policy. The green jurisdictions, which as you can see here are much fewer, do not require that their licensed attorneys have a JD from an ABA law school. So they would accept our accredited law schools and registered law schools. And then the purple states here do not require licensed attorneys to receive their JD from an ABA law school. However, reciprocity is required, which also limits California licensed attorneys. The yellow states here allow ABA law schools and do not have a position on either of those policies. And as you can see here, there are 5 states, including California, that require all attorneys to take an exam. So where the commission, we brought feedback to the commission about the fact that the public comments were clear that we needed more, that there was a desire to have more emphasis or specificity on whether the commission agreed to a reciprocity model or a comity model, and also its position on how this impacts non-ABA law school graduates. Maybe just one more. Okay, perfect. So at the April meeting, the BRC discussed the different policy implications and revised their recommendation as follows. Basically, the BRC adopted reciprocity, meaning that we would extend somebody the ability to become licensed in California without sitting for the California bar exam, as long as the attorney's in good standing, that the licensing state provides the same privilege to California licensed attorneys. And also, they made a determination that this privilege should also be extended to non-ABA, beyond just ABA graduates. So regardless of an educational background, and also based on a certain number of years of practice, people would be able to become licensed. The other thing to note here is that this would apply to non-ABA law school graduates, as well as graduates of those participating in the law office study program. Also, in terms of the decision as to what happens to foreign attorneys, the recommendation was to defer that decision until the new California bar exam has been implemented, and revisit that at that time. All right, next slide, please.
We're back to Josh.
Yeah, I mean, I think that when you look at this slide deck, hopefully you guys had a chance to review the actual report. There's a couple just big topics I want to make sure that are very clear. Number one, the decision not to move forward with an alternative was one that was long, arduous, and painstaking. We had a real split of decisions. We had some very talented individuals on this commission, some from academia, some from practitioners, and there was just a split in whether or not an alternative pathway made sense. And we attempted, as you probably saw in the report, on a couple of occasions to try some testing and different methods, and we just couldn't get there. With regard to the California specific exam, some big picture items, it was very clear to us that it was important to have more control. As we all know, we are a large jurisdiction, and we really didn't feel like we had any control around the next gen. We'd never seen the next gen. Weren't able to move topics if need be. and had very little control. So it was important to have some control. And then in addition, around topics, it was just very clear as a theme that the commission believed that the exam historically has been focused on a lot of memorization, and that probably is not the best way forward in the commission's recommendations and thought process. Less kind of doctrinal memorization, more practice analysis, and trying to focus on what would be the main, not that any topic is less important than another topic, but trying to focus on some of the main topics in doing that, and on skills. And, you know, with that, again, I just want to give my heartfelt thanks to not only the commission, but also the public. We had a tremendous amount of public comment at our meetings and on the report. There were a lot of opinions, and they were acknowledged, appreciated, and I think really helped form the final decision.
Thank you, Josh. Thank you, Audrey and Amy. And indeed, thanks to the commission and all the members of the public. We had folks here yesterday as well, in person and on the phone, offering public comment on this item. If we could have the presentation taken down, please.
So Ruben, I just want to, we just want to highlight the recommendations on the
Yeah,
last.
that's what I was going to ask for. Great.
Yes.
Thank you.
All right. So just to summarize what the full set of recommendations include is we're asking the request is to approve these recommendations that California develop its own exam. Again, just as a reminder, it's covering some federal law and California law, that we adopt the CAPA recommendation topics and add professional responsibility to that. That we adopt the CAPA recommended skills, that there's a focus on skills and application versus memorization, that the state bar and subject matter experts are tasked with exam development, and that we recommend a reciprocity model for attorneys from other states, regardless of their educational background. And should the board agree to those recommendations, this is the proposed motion.
Great. Thank you so much.
Sure.
Trustees, any questions for any of the presenters? Vice Chair Stallings, please.
All right, I just want to extend my thanks for this just incredibly detailed amount of work, and just the amount of stakeholders that really had to be pulled together in order to present this the topic to the board. So thank you. And Josh, great to see you. Hope all is well. I guess one of the things that I kind of my initial concern in looking at the pared down topics was thinking back to my own law school experience, my own experience on the bar exam. And it's this idea that if a topic is not on the bar exam, then perhaps people don't take it as seriously in law school, or even pursue it in law school. And so I know we've had a significant amount of public comment on the missing, or quote unquote missing topics, paring down from the 13 down to sounds like 9. A lot of these decisions were pretty close as far as which topics to include. What thought was there any thought given to the impact of not having a topic on the bar exam, and then potential law students failing to take those particular classes in law school, and what impact that might have on the public upon potential clients? What sort of thought was given to that?
Can I just jump in and say the Blue Ribbon Commission, this recommendation is to align the topics on the bar exam with the CAPA topics. And I did ask Ron B. to join us. We see him there in the bottom, because Ron was lead staff on that effort. And so I think, to the extent, Brandon, that you want to know about I think the real question is why certain topics were not recommended following the CAPA effort. Ron is probably the best person to explain that, unless Josh, Amy, or Audrey, you wanted to weigh in.
I mean, I think it'd be great to start with Ron because that'll give us a little background on it, and then I'm happy to weigh in after that.
Hello, this is Ron. From the initial study design of CAPA study, it was clear that we have started out with a framework as a guidance for gathering evidence. And that evidence is about attorney practice, what they do, so that we could have a scope of a study reaching some alignment between what the attorneys practice on a day-to-day basis and then what's covered on the bar exam. We also are aware that the alignment is not only between attorney practice in the real world and the bar exam, but also in what law school teaches and students learn. So the three-way alignment is pretty much the foundation of the initial design of the study. And how to gather the information. We started out by convening a panel of attorneys to come up with a classification of knowledge domains and skill and practice domains. So with the two dimensions of the attorney practice, knowledge and practice skills, we came out with 19 attorney knowledge domains and a similar number of practice skill sets. With that as the basis, the information that we gather from the survey is to identify several dimensions in their practice. One is the frequency. How often do they use different skill sets and knowledge? The other is the importance, criticality, or potential harm if you don't know enough about the subject matter. So those are the two main dimensions, although we also in a second version of the survey cover something about the depth of knowledge in each of those knowledge areas. But at the end of the survey, we came up with the ranking of the knowledge domains as well as skill sets. The ranking is based on a composite of the two dimensions that I mentioned in terms of frequency and the importance, with a maximum score of 20, and with all of the 19 ranked together, we have more than half, a little more than half, with the ranking composite score above 10. And that is the basis for deliberation about the meaning of the ranking, not so much as the final decision for selection of the relevant topics to be covered on the bar exam. And as we go through the ranking, it was clear some of them that's considered foundational were not ranked very high. For example, constitutional law and real property. These are not ranked as high as, for example, employment. So through several meetings of the working group members, all of these different factors were taken into consideration. And with one of the drivers being that the purpose of the study is to minimize some of the issues that's often associated with the bar exam, which is memorization of the subject matters. So out of 19, where do you start to just make a selection about the important ones and the frequently used ones? So at the end, there were some balance of all of these factors considered, and the ones that's ranked lower, but also not considered to be critical foundational subject matters, were not included at the end. And another thing is, remedy is an example that even though had a lower ranking, but initial classification of the knowledge domain, it was actually embedded into the 19. I think it was partly embedded into torts as well as contract. So remedy being part of the existing subject matter, but not included, it actually is included in a different way as a subcategory. So that is the process and the considerations behind selecting the 8 categories.
So Ron, I think we've heard a lot of public comment about family law, estates and trusts, and maybe some business law areas. Those all then fell out of CAPA based on that sort of ranking exercise that you're talking about.
Yes. And there's recognition those are not unimportant. For example, family law is ranked higher than real property. Real property was selected, but family law was not. So the distinction there is what's considered foundational and what's considered might be specialty areas. So with that balance, some more weight was given to the foundational knowledge areas relative to the what's considered specialized areas. Similarly to employment. Employment was ranked high on both dimensions, higher than criminal law and procedure. But it's also considered a specialized knowledge area.
Yeah, and so I guess my ultimate question though is, was there any consideration given to perhaps intended or unintended consequences of not having, the traditional topics on the bar exam, and what downstream effect that would have on future law students choosing not to take certain areas, or not getting a foundational area in these other kind of historically learned topics, and what effect that might have on public protection, future clients not being able to take advantage of an applicant and then hopefully a practitioner that has a baseline understanding of those other traditional areas.
Yeah, I mean, the short answer to that is no. I mean, we focused on skills and foundation, and what we used minimum competence as our North Star, and we kept going back to what are the most important skills that you will need, and what is the foundational work. And because a lot of these topics are ones that you can learn the law on if you have the skills and you have the foundation. As an example, civil procedure, we'll run through all of them. But we had a number of academics, professors and administrators on the commission, and it was never raised. There was a lot of conversation that, what they do today is teach to the bar exam, and that they don't believe that to the current bar exam, and they don't believe that is beneficial to anybody. But we did not have, it was never raised a specific question by limiting the topics. Does that mean that, and I believe that is your question, will there be less students that choose to take one of those topics in law school? That was not raised. We did not discuss that.
Thank you for the question and the responses. Trustee Sowell, please.
Mr. Petula, I just want to thank you and thank the members of the commission, as well as the staff team, for putting together what was an incredible, I guess, amount of work and compilation of lots of thoughts and ideas into this set of recommendations. As you know, I am a public non-lawyer member of the Board of Trustees, and so forgive me if this if this has been vetted in some of the other answers or responses. But the thought that came to mind for me, I've never sat for a bar exam, never been to law school. But what is the practical effect of some of these recommendations on law schools themselves? I'd like to hear maybe a little bit more about that.
I think the previous question kind of spoke a little to this, and that is we're recommending that 9 topics are incorporated in the future bar exam from the 13 that we have now. And one of the things that is practice is a lot of law schools teach to the bar exam, meaning that there's emphasis on the topics that are covered on the bar exam. So that is potentially one of the implications with this, the recommendation on the topic areas. One of the recommendation on the skills, so there's a specific set of skills that are going to be incorporated in the bar exam, and some of them exist now, such as looking at, for example, research, issue spotting, fact gathering, that exists today on the exam as part of the process. But the skills of, for example, communication, negotiation, dispute resolution, we're going to have to find a way to test that on the future bar exam as a skill, which is going to be a very different exam than we have now. And the idea is to create more real life scenario vignettes, more live examples like the performance tests that we have now as part of that exam. So in terms of actual changes, I think that is one that we will, it's going to be a challenge to design, but it's also going to address the concerns that were expressed or have been expressed about the bar exam. And it's something that will be a big change for California.
I think I would say too, Amy, the law school representatives that were on the Blue Ribbon Commission were excited about de-emphasizing that kind of and regurgitation and having more applied and practical scenario-based kind of questions developed.
Yeah, I'm going to do my best to give you the consensus of the commission. It's kind of hard to do because unfortunately some of my own personal thoughts find their way in there. But generally speaking, there was a consensus that the current exam is an exam that is very high intensity, needs a long period of time to study for with a lot of doctrinal memorization, including, by the way, currently most people take an exam prep, which has a cost to it, and most people have to take time off to study for it. And there's all of these factors that go into it. And so the conversation of the commission was some of that memorization is not necessary to show minimum competence. It's really the skills of being a lawyer, understanding the base. And I think the exam has moved that way over time with some kind of more practice type questions and issue spotting, et cetera, as Amy pointed out. But I think there was a thought process that it's time to take the next step and make this more practitioner exam and less memorization.
And to add to Josh's point too, one of the scholars emphasized that the exam should be one that all attorneys should be able to pass. That's ideally how an exam should be developed. And I think that's the aspiration here, is to create an exam that would apply the skills that are currently being applied. So, you know, an attorney that would be taking this exam wouldn't have to memorize as much. It would just, it should be something that people in the industry at the moment would be able to pass.
And so do you feel like this is going to require some changes in the way, sort of the pedagogy, as well as the way that law schools are instructing students?
Yeah, I think that was the conversation and the hope. I mean, I think we as lawyers always believe that we have this skill set of critical thinking that was taught at an early time in law school. And I think that there are some folks that believe that has been lost to some extent as the law schools, our bar passage rates have been lower, and law schools have been really focused on trying to get those rates up and teaching specifically to the test. And so there was a conversation about how do we get back to that skills-based critical thinking, you know, with the importance of the foundation.
Thank you.
Thank you. Trustee Knoll, please.
Thank you, Mr. Chair. I'd like to ask, well, first of all, let me just say, my kudos to you guys on this incredible work over 19 meetings, trying to get to what you were charged with. I can't imagine how difficult this was for you. And you've come up with the best product that you believe you could. So, you know, I mean, my questions have to do with my disappointments. You know, my disappointment in that, although having it as a charge and discussing it and not coming to consensus, there was no recommendation for any kind of non-exam pathway to licensure. And to that end, I'd like to ask Ms. Nunez if you could please bring up the panel that talked. There's only one panel that mentioned these words. One word was equity, and the other was, I think, something about avoiding desperate treatment to people of color or something like that. And that was on one slide. I want to see what it says, and I have a question for you.
Yes, it's in slide 4 on the guiding principles.
Okay.
I think it might be this one about the recommendation on exam design. Is this the one? Is this the slide you were thinking of about the exam design and the minimizing disparate performance impact?
Yeah, this is kind of it. There's another one though.
It's the guiding
This one?
principles.
Yeah, is it this one?
Yes. Here's my question. Nowadays, we see this all the time. This was never, I don't think, a consideration until recently. And I want to know, what about the discussion? What was the discussion on how to ensure equity and how to minimize desperate performance? How will this exam do that?
So we talked about within the design of an exam that there are some methods for ensuring that they're culturally competent, so that somebody from any background could, for example, understand the concept. So developing a universal exam is one of the principles, I think, that's implied in the recommendation, that we need a fair and equitable exam. I think, and that's ensuring that we're using, culturally appropriate language that's well understood. Also, the emphasis on the skills rather than memorization, I think, is a method or something that could, the approach that will be taken in the future bar exam. So I think that also the fact that they're going to be more real life scenario questions, I think will facilitate that. And that is try to reduce the amount of potential bias that could be introduced in the exam itself. So those were some of the thoughts and discussions around the recommendation to develop an exam that aims for that fairness and equity.
And then when that exam is turned over to some exam experts, we will trust that they know that they're responsible to do this.
Yes, and I think the idea is to work with them in the development from initially. So it's not like we would develop the exam and hand it over. I believe that we're going to rely on expert exam developers that work in this area.
Yeah, if I can, Amy, I'd like to address that and then an alternative for a moment, because it was very interesting to me. So number one, we did focus on the fact that we believe there's some unfairness in the process, we being the commission, on having to take a exam prep course at a large cost, having to study for a long period of time in the memorization portion of the exam, and obviously that's when nobody's getting any income. And there is some disparity in that. And then specifically on the exam itself, as Amy laid out, we talked about some of the issues that we would like resolved in the future exam when it's being drafted. What I found most interesting about the alternative pathway that we did have many discussions on, it was actually equity and disparate impact. That was one of the main reasons we weren't able to move forward on the alternative. There was a small group, there was kind of a swing vote in the commission that believed that it would be much more difficult to get practice, externships, specifics, post law school. They didn't have the same maybe connectivity, relationships, and they thought it would be very difficult for them to do that, and so just couldn't support, because it would be a non-paying period of time where they would be working in the practice of law before they could actually take some sort of alternative exam assessment.
Well, I wasn't going to talk on that one, but it could be paying. It doesn't have to be non-paying. There are many things that one can throw up to say why an alternative to what we're doing now wouldn't work. But there's also it has to be a desire to think outside the box and to see what California can do for its citizenry. People that maybe can't afford law school, people that can't. It's not a question of equity necessarily for groups of people. It is the fact that people should be encouraged, if they have the desire and can meet a skill test or can show their skills throughout a year or even two of internship, if you will, that there can be a way to develop that so it does meet all the things that people throw at you about why it wouldn't work. That's all. I mean, that's all I wanted to say. I'm not sure I could come up with it, but the idea for me is that a Blue Ribbon Commission has to tear down all the walls and try to build it up again in a way that is best for all Californians. And I just want to thank you very much. I appreciate your work, and I appreciate your answers to my questions. Thank you.
Thank you for the question and the responses and the conversation. Trustee Good, please.
Thank you, Chair. And I think I'm going to be piling on a bit to what Trustee Knoll just said. So I appreciate very much your comments there. So thank you. And again, I do want to echo the chorus of voices that has thanked the Blue Ribbon Commission and its chair, who we have here, and all the staff working on it for their extremely hard work on, frankly, a Herculean effort, right? I mean, really a very time-intensive and difficult topic to undertake, and I very much appreciate all of the work that everybody did on it. You know, taking a step back from this, I am very disappointed that there was not an alternative pathway to licensure, you know, proposed, or that was a consensus of the Blue Ribbon Commission, so that we could consider it and look at it before us. I recognize that it's a tough topic. There are many different views, but taking a step back, looking at the demographics of the California attorney population, you know, the attorney population is not very diverse. It is nowhere close to reflecting the demographics of the population of California, which I think is the right rubric by which to examine the demographics of the California lawyer population, as sort of COAF has demonstrated in its leadership on these topics and other things. And part of looking at an alternative pathway, as Trustee Knoll just very eloquently said, is to look at providing opportunities and accessibility to the legal profession, to those who may not find it very accessible right now, to be able to go to law school, incur hundreds of thousands of dollars of debt, and take a bar exam that historically has disadvantaged people from historically underrepresented communities in terms of the pass rate, and so forth and so on. So I think it's important that we continue to explore alternative pathways to licensure and not just kill that discussion completely by moving this report onto the Supreme Court. And so I personally would like to talk about what are some options for this to continue to be a discussion and a study point at the bar, so that perhaps in the future we might have some proposals in this regard, perhaps based upon what's happening in other states right now. You know, for my own view, I read all of the comments, and I also heard some of the public comments yesterday, who were very focused on the fact that an alternative pathway was essential, frankly, to making the California attorney population more diverse, equitable, and inclusive. I'm also cognizant that some of my former colleagues on COAF are concerned that an alternative pathway may have the reverse effect, and may create an alternative pathway just for the privileged few. So there are obviously a lot of different views on it. I'm not proposing to reconcile that now, but I think it's sufficiently important for us to continue to study and review and see what's happening elsewhere, and potentially for something to come back to us on this issue in the near term. So I'm not ready to say, you know, it's over. You know, we're not going to think about this anymore just because the Blue Ribbon Commission couldn't reach a consensus. So I'd be interested in hearing from others about what some of the opportunities for study and comment and what that might look like, how that might be reflected in a resolution that we can consider. That's all that I have. But again, thank you so much for your work.
Thank you, Trustee Good. Trustee Stallings had a follow-up, and then we'll go to Trustee Tony, please.
All right, thank you. And I know that this topic isn't necessarily about law school costs, but Trustee Good's comments kind of triggered some discussions that we've had in the past. But Amy, I don't know if you're in a position to talk about this, but my recollection is that with California really leading the way in several different approaches to law school, having our Cal registered, and then also the state bar accredited schools, that has reduced costs, and this pathway for individuals with less economic means to be able to get into law school. And I think for like a registered school, the average cost was around $30,000 total, and then Cal accredited was around like $65,000 total. Are those numbers?
That's about right. Yes.
Okay. And so, you know, I know that we're going to be talking at later dates on the state bar continuing to be in the business of accreditation, but I would just offer up that the state bar has taken leadership in providing those other means. Amy, are there any other staff members who want to talk about ways that we've tried to be responsive to the needs of individuals coming to the table with less economic means?
You've highlighted the registered law schools and accredited law schools as alternatives to in a JD program. The other program that exists in an Office of Admissions is the Law Office Study Program. And that's a way that people are able to meet the legal education requirements and become licensed. And those are much less costly than a tuition. There is the investment of time that's required for the program. Students register with us. Students in the Law Office Study Program register with us. The registration altogether, it would lead to a legal education that would pursue under a judge or under an attorney. And in terms of administration, the cost for all of that is less than, I think, $3,000 right now in terms of what's required administratively. But it is another avenue. And it's a small program right now. We don't have too many people that are taking advantage of that.
Thank you, Trustee Stallings, for the question, and I think what will probably be a further conversation somewhere down the line. I will just sort of note that to the extent we as an agency can put the word out about some of what Amy just talked about in particular, all to the good, and to enlist the support of the law, maybe it's the universities, undergrads. Trustee Tony.
Thank you. I have more comments than questions. And my first comment is, this is the first time earlier this week that I've had a chance to read the report, read all the dissenting comments, which there were, I think, a large number, 18-member Blue Ribbon Commission, and we've got 8 members who submitted written dissents. That's significant to me. Okay, so we have a Blue Ribbon Commission that doesn't appear to have achieved much consensus. And so one thing I want to suggest is that we have this discussion, but we put off a vote until July, when we can have more discussion. Because for big issues like this, I always think it's good practice to not vote on it the meeting it comes up, that it's good. You know how a lot of places have a first reading and a second reading kind of thing? There's a reason for that, okay? Particularly when we're presented with a proposal that clearly has a wide range of views within it. It's easier if there was a clear consensus. Then it's easier to say, okay, the commission did their work, and maybe we can just go ahead and say, we'll pass it along. So that was a comment that Trustee Good made, that maybe this isn't quite ready to pass along. And I will note that from my count, it appears that of the 18 members, 16 were attorneys. That's pretty attorney heavy, I have to say. And I think it's part of what led to the inability to come up with any recommendation on exploring alternatives. It wasn't even, this is the one we recommend, but even to explore them. I'm actually surprised as many people in this committee did support that, given its composition. So on this question, because I really want to echo Trustee Knoll and Trustee Good's disappointment that an alternative was not, even the exploration of alternative was not agreed upon. When you're trying to come up with alternative solutions or proposals, which from reading this, it appears that the Supreme Court is actually interested in, is interested in thinking about this. The first thing is you have people who are supportive of alternatives and those who aren't. And that's to be expected within any profession, okay? People who are kind of, worried about changing things, and people who want to change it. And I know even among attorneys that I know from talking to my own staff of attorneys that there are differences of opinion, and it's not just because they're attorneys doesn't mean that they're automatically opposed to alternatives to licensure from the bar exam. So here's what I'm going to suggest as a way forward. If you want, and it does make sense for the majority of people on any committee to be attorneys who are looking at the bar exam, okay? There's value to that. Here's what I would suggest, that you want people who already think an alternative is a good idea to be on the committee to come up with a proposal, okay? So that's one. There are 2 options I see. One is that the state bar can form its own ad hoc committee look for some volunteers, okay? And solicit attorneys who say, yes, I'm interested in developing and designing proposals for an alternative. That way, one will be yielded. The second way is it's clear that some of the members of the Blue Ribbon Commission do support an alternative. We could ask them to, because they've already discussed this for a long time, instead of reinventing the wheel, we could ask them to, as an ad hoc committee of the Blue Ribbon Commission, to present to the board what they think. So I just think there are ways for us to move forward. I think there are ways, but it's hard if we feel like we have to make the decision today. I wouldn't be surprised if the members of the Blue Ribbon Commission who would support an alternative, I'd be surprised if, I think there's at least a chance that they would say, we'd love to present an alternative. And, if they need till July, September, whatever, there can be a discussion about, well, we'll give you a couple extra months, 3 or 4 extra months to come to us with what you would have created. So those are my comments and suggestions.
Looking around the table, I don't see any raised hands. So I think at this point, Trustee Tony, I'm going to ask if you want to put a motion on the table to see if there's a second and figure out whether there's some majority of the board who wants to explore a path that you recommend.
I have to think about this because, I'm thinking in real time.
Yeah,
Sure.
I was gonna
Yeah.
say, I was listening to you, and it was helping me form my own thoughts, because certainly in the past, we've done things like, we're being asked, the board is being asked to transmit a report of this commission to the Supreme Court, right? So it wouldn't be appropriate, obviously, for the board to try to modify those recommendations. But in the cover letter transmittal, as we have done on multiple occasions in the past, we could indicate, these are the recommendations of this commission. However, the Board of Trustees on this particular issue, for example, feels otherwise. So that's one option. That could move it today. What you're suggesting, though, resonates with me because it's more action-oriented. And if we wanted to ask some group of people from the BRC, for example, or others, to come up with a actual proposal for an alternative pathway that the board would consider. And I'm thinking that those, again, they don't need to, harking back to some of our discussions yesterday, but they don't need to be mutually exclusive. Perhaps the board advances the Blue Ribbon Commission report to the court, and the board takes action to ask some group of folks to develop a proposal for an alternative pathway that the board would then submit to the court. And if we wanted to do that, I would maybe say, Chair Duran, to give us a moment as the proverbial us, the staff that's out here, some time to craft a resolution. Maybe we could go to another agenda item and come back if folks were interested in this kind of dual approach.
Trustee Good's hand went up first.
I was going to say only if Josh is a part of it.
Trustee Good, and then Trustee Chen, and certainly Mr. Petula, if you want to weigh in on this, I'm sure we'd welcome your input.
So very quickly, yes, I would support such a resolution. So I'm looking forward to what the staff puts together so that we can do this on 2 tracks. And also, I recognize Mr. Petula's immense time contribution already to the Blue Ribbon Commission. And I think the second step could just be done by those members who are really interested in creating an alternative pathway as they see fit, because I know everybody's time is limited and this took a lot of time already. Thank you. But thanks, Leah, for the suggestion. I like it.
Trustee Chen.
As do I.
Oh, go ahead.
No, I just said as do I. That's all. I agree with.
Trustee Knowles giving a thumbs up there.
Sorry.
Okay, yeah,
Sorry.
no worries. I'm about to say the same thing. I agree with Leah's suggestion. And in terms of crafting the language for what it means to explore an alternative for licensure to practice law, I mean, the Blue Ribbon Commission already considered and was not able to reach a majority vote on a number of these things. So you could just look to the language of those prior motions that start on something like page 11 of the recommendations and the materials we received. There's already language on that. And then I would encourage whoever takes it up in exploring the alternative pathway to take a look at our experience and the data that we have from the provisional licensure program.
Thank you. Trustee Broughton, please.
Yes, thank you. I want to say hello to Josh and Amy. I mean, for those of you that don't know, a few years ago when we had COVID, we had to do a completely remote bar exam that was never done in the history of our country, certainly in California. And Josh and Amy and Donna led the effort to do that. And it came off pretty much without a hitch. And it was a Herculean effort. And I still applaud those folks for doing that. And here Josh comes back to work on another committee. So I wanted to say hi to Josh. And again, thanks for all your hard work. I support Leah's recommendation. I like that. I think we can send the recommendation that is in front of us off to the Supreme Court and continue to study the other options. However, I do agree with Highland that this was already looked at by the commission. I don't know how in the world we're going to be coming up with one, but I certainly think it's good to look at it.
Chair, I don't have an opinion, but I just do want to let everybody know that there was, and you saw it in the report, but I'm going to give you a little bit of color. There are some really obviously strong feelings on both sides. And the folks that, even the folks that I think ultimately did not vote to explore it, they did participate and vocally and thoughtfully in the process of thinking about, as Trustee Knowles said, after we broke the walls down, how to build them back up. And we started those conversations, and I think there's a lot of good information that can be picked up from there. We actually never really got to those specifics because it broke down at the moment that nobody wanted to continue to explore. But we looked at hours and hours and hours of other programs and started to talk about what would work. And so there is a tremendous amount of knowledge and that I think you can start with.
Thank you, Josh. Let's do this. It's 11 o'clock, probably a good time for a bio break. Give everybody a chance to stretch their legs, and we'll see whether when we come back there's further resolution from staff or otherwise. Why don't we break for 10 minutes, please? Okay, we're recording. I'm going to ask the trustees who are remote to pop back into the Zoom. I'm certainly hoping we still have Mr. Petula, but completely understand. You're there. Great. Thanks, Josh. Ms. Nunez, you're back. So when we broke, we were hopeful that there might be an addition to the resolution for the board to consider. I'm going to do a fact check on that with somebody. I'm not even sure who to look at. Is it you, Ms. Wilson, or is it?
I'm changing it, Audrey. So
Oh, you are.
Yeah, let me send it now to Luisa and Alfredo.
Great. So it sounds like we'll get something up on the screen for the trustees and for those of us who, for those folks in the public who are joining us to take a look at. I will let it sit there for a sec so those of us who are visual learners can absorb it. And then I'm hoping someone's going to discuss it. So the area of focus here is that further resolve the second resolution, the third resolution paragraph, excuse me. And then when folks are ready, I think I'd like to ask Trustee Tony to, whether he's got any input or discussion on this, because it was your comment that's prompted it. Thank you.
Thank you very much. In principle, I definitely support this. I'd like to make one adjustment, which is to ask BRC members, just to, the further resolved at the third one, yeah. Wait, instead of to ask those who, just to say, make it clear, BRC commissioners, however we call them, okay? Members, yeah, okay, thank you. Who indicated support for a bar exam, because some of the dissents were on, had to do with the exam content as opposed to the alternatives. Not all of them were on the same topic. So that'd be my only suggestion for clarification.
Great, I think it's well taken. Any discussion, questions? Any other trustees want to offer more language, different language? Trustee Null, I see you there.
Yeah, thanks. I wonder if we could just stop with a period after its July meeting. If you give folks till September, that's how long it'll take. And it seems to me that this is pretty much, with the rest of the report moving on to the Supreme Court, it is, I think, important that this happen quickly. And they'll have 2 months.
Thanks, Greg. Trustee Good.
Just with summer vacations and considering the amount of work that would be required, I think September is still aggressive. So I would give them more time rather than less time.
Trustee Sowell.
This may be semantics, and but in the first resolve clause, where it says the Board of Trustees approve the final report and recommendations, are we actually approving all the recommendations? Because it does appear to be that there's some concern about some of the recommendations. And so
that's right.
And so should it just be resolved that the Board of Trustees approve the final report of the Blue Ribbon Commission?
Do you mean receives instead of approve?
Yes.
I don't know. Is that what you meant, Arnie?
You know, I just want to make sure that it, because it appears to be that we aren't necessarily in agreement with the entirety of the recommendations. I don't know if there's too much in the way of semantics here, but just approve seems to me that we are affirmatively.
That's right. I think receives is right, because it goes with the second paragraph better.
Okay, the change has been made and it's up there for your review, trustees.
Mr. Chair.
Yes, sir.
I am persuaded that I thought this was going to be relatively narrow in that we were doing blue ribbon commissioners that had ideas already, and we're just going to put them together. And I thought 2 months was enough. But I'm persuaded by Trustee Good that we should at least say consideration at its September meeting, maybe, maybe it's not as urgent or as difficult, or it's more difficult than I thought, maybe. Yeah, July or
So let's
September.
just say at its September meeting and just skip July entirely.
Well, that's what Trustee Good thinks, I think. So I'd go with it. We could throw in July or September. Maybe they've got something ready to go. And they just could get consensus on it.
Leave open the possibility.
Yeah.
Trustee Good, are you okay with that? Let's hope for the best. We still got September as a
Yeah.
potential deadline up there. I'd like to just ask a question to the board, and that is, do we want to take a little bit of a position of, it's almost as if we're just the pass-through from the commission to the court, without offering any opinion on the other issues that the commission worked on and its recommendations. I understand that the alternative licensure issue, the issue that we're talking about, alternative to a test, is an important issue, but I think it's important for the board to express to the court that the rest of the work, all the other recommendations of the board or of the commission, are important, and that we do indeed approve moving them on to the court for consideration.
Yeah, I would support that.
So would that be in the second further resolve that transmit the final report to the Supreme Court, indicating the board's support for the bar exam and reciprocity related recommendations? I mean, I think that's.
Or is it easier just to say everything except for the absence of an alternative path option? That might be just easier.
Indicating the board's support
for the recommendations, essentially with the additional work related to the alternative to a test. I'm not good on the language right now, I'm sorry.
Really, there was no recommendation at all about the bar exam non-alternative pathway. So I don't know that this is actually inaccurate. You agree with the recommendations, you just want, you want an additional recommendation.
Yeah, we're taking the additional step of refinement, further refinement essentially on the issue of the alternative test, which, by the way, I think is encapsulated in the changes that are on the screen right now. Greg, go ahead.
This brings us back, unfortunately. I think this brings us back to what Trustee Tony said when he started, that he was just reading this and didn't want to make a decision today and wanted it put off to July so that we could say what we approve, don't approve. And I'm not sure, as sure as some people apparently, that we would automatically approve all recommendations except for the lack of one. We absolutely may. But I wonder if there aren't some commissioners that might think, if we don't study this a little more to July, that maybe we're not, I don't know. I'd like to hear from Trustee Tony, and who was, I guess, going to make a motion early on about putting a decision on this, on any resolution, off until July.
Thank you, Trustee Knoll. Trustee Shelby has raised her hand, and then I think we're going to look to Trustee Tony as well.
I just have a question in relation to timing. Is this something that can be pushed back to July, just this item pushed back to July, or are we under time constraints and something has to go to the Supreme Court within a particular time frame?
We're under time constraints to the extent that the Blue Ribbon Commission established a time frame, and that has been relayed to the Supreme Court through the Supreme Court's representative on the Blue Ribbon Commission. They're expecting to receive the recommendations or the report. That being said, I don't know what the actual impact would be of a delay. I would say, I think though, at a minimum, the further resolve should go forward, so that that work could begin, so that the board could have something to consider sooner rather than later. That's all I would say.
Thank you. Trustee Tony, please.
For myself, I have less opinions about what's on the bar exam. If we were to postpone it, my questions that I just don't feel like we have enough time to do in one sitting have more to do. Right now, they're rhetorical questions. So an example of a rhetorical question is, what's the meaning of the fact that the most recent bar exam pass rate was less than 33%, less than a third? Okay, I mean, what's that really mean? Does it mean that 2/3 of the people who finish law school are not competent? Does it mean that people are not studying hard enough? Does it mean that the curriculum, I mean, there are a lot of deep questions that I wish we could get into. I don't think today, we have other things on our agenda, so I didn't bring that up, but that's what I would have done if we had postponed it to July. And maybe some of these questions, I could just have conversations with some of the staff and learn more about it. But, you know, it was more the exam, you know, those type of questions, the bigger picture questions, and then the alternatives to the exam. I don't know whether the Supreme Court has a strong feeling of, you know, we need something now, and we give them something now and something later, or whether they'd prefer kind of like a package from what they requested. They requested, I thought, a package, 2 questions to be addressed. So I could go either way on this.
Okay, thank you. Any other thoughts or opinions before I share my own? I think what I'd like to say is I'm inclined to move this to the court now with the work of the Blue Ribbon Commission as it was presented to us, right? I just think I want to be very respectful of everyone's time, and not that this exercise is disrespectful, but certainly I don't think that I'm going to be in a position as a member of this board to meaningfully alter their recommendations, because I did not go through the 19 meetings and hundreds of hours of analysis. I think that the board has taken our responsibility with respect to the alternative to a test seriously enough to actually start some action on that and get it going and ask for some movement by September. And I think that's a very good outcome, quite frankly, given the public comment we heard yesterday, the discussion we've had here today. Those are my thoughts.
I think I agree with you, Mr. Chair. I think we should move forward. I think I pretty much agree with all the recommendations except for the recommendation not having an alternate license program. So I think we should move forward.
So, Mr. Buenaventura, I'm going to take that as a motion, if you don't mind.
Sure.
Is there a second to the motion on the screen?
I'll second.
Trustee Tony's got the second. If there's no further debate, we'll have the roll call, please.
Broughton,
Aye.
Buenaventura,
Aye.
Chen,
Aye.
Cisneros,
Aye.
Good,
Aye.
Knoll, Trustee Knoll,
You're on mute, but I think I see you saying yes.
Yeah, aye, sorry.
it's okay. Shelby,
Aye.
Soel,
Aye.
Stallings,
Aye.
Tony,
Aye.
Duran.
Aye.
11 ayes, 0 nays, motion carries.
Thank you, everyone. Thank you again, Mr. Petula, and to all the commission.
Thank you.
Thank you, Ms. Nunez. Thank you, Ms. Ching. Okay, if I recall, we left off yesterday, going back to our regular agenda at item 60-8. 60-8, yes. This is a discussion on a potential policy or rule change regarding the notice to respondents of all closed complaints and the elimination of private reprovals. Certainly a topic that has garnered a lot of commentary in various circles. So we're looking forward to hearing what you have to say, Mr. Cardona.
I have a name tag. I feel validated. So this is an item for initial discussion on two topics. And before I get into what those two topics are, I will let you know that we are just looking for guidance as to whether you want us to move further on these topics, in which case we would put together more detail and potentially proposals on each of the two topics and return to the board with the proposal and more detail in September, with the goal of then having any necessary rule changes presented to the board in November, which is the second time when the board considers rule changes. So with that in mind, the two topics, the first of them is, should we notify respondents, that is, when we get a complaint against an attorney, should we in all instances notify those attorneys that we have received the complaint? That would be a change in our current procedure. Under our current procedures, we close roughly at any given time between 40 and 60% of our complaints in intake before they are forwarded for investigation. Those complaints that we close in intake, we typically do not notify the attorney that we have received the complaint. The determination in intake is basically there aren't even enough facts stated in the complaint to move forward with an investigation, or even if there are facts, it's not a type of violation that would be likely to result in any discipline, and so there's no basis for moving it forward to investigation.
I'm sorry, George, can I hit a pause button there? I know you're very early in your presentation, but when that happens, when there aren't enough facts from the complainant to move forward with an investigation, do you go back to the complainant and ask for more facts?
In some instances, yes. In other words, if it appears that the complainant may have additional facts that they haven't given us, we would reach back to the complainant and say, hey, your complaint doesn't, we need this additional information before we can assess whether your complaint warrants investigation. And so we would do that. We would reach back to the complainant, give them an opportunity to give us additional information before making that determination. So having gone through that process, if in fact they close there, the respondent doesn't get notice. If cases move to investigation, in most instances, one of the first steps of the investigation is to send a letter to the attorney, the person who is being complained about, saying, hey, we've received these allegations. Can you give us your response to these allegations? So that we have that attorney's view of what the allegations are and why they are or aren't meritorious. Most typically, that's a letter back to us saying, look, the complainant says I did this, but in fact, I didn't do that. I did this, and by the way, here are the 7 emails I have that show that I did this. Or alternatively, they respond, and then we make our decisions as to how to move forward with the case. So the question is, the first issue is, should we be giving notice to respondents, to attorneys, of every complaint we receive against them, even if we conclude at the intake stage generally that that complaint simply doesn't have merit, doesn't have enough facts for us to even move it forward to investigation. And obviously there are pros and cons to this that I've tried to lay out, at least initially, in the discussion section of what we laid out. And the question is, given those pros and cons, is there an interest in us pursuing this further and coming up with a proposal and doing more assessment, in essence, reaching out to stakeholders, reaching out in this instance to stakeholders to get their interests in this, reaching out to, in this instance, malpractice carriers to find out what the impact of this would potentially be on attorneys' malpractice. If they get notice of a complaint, would they be obligated to notify their malpractice carrier? Would that have impact? And reaching out to stakeholders in 2 instances, what would be the adverse impact? Would there be a beneficial impact in us notifying you that you'd had a complaint and potentially adding to that notification a set of resources that you could go to to address the type of conduct that was complained about, even though we've concluded that that doesn't have merit. Those are kind of the balancing sides of that. So that's the first issue.
And why don't we take a pause there, because I see some hands. Trustee Knoll and Trustee Good, your hands are both up. I think Knoll's may be leftover. Looks like it is. Trustee Good, please.
I was just going to say, you know, from my perspective, I don't think that this is a good use of OCTC's resources to delve into this question. The number of stakeholders you'd have to consult sounded exhausting to me. And I think that OCTC's resources are better spent on pursuing violations of the discipline system and getting attorneys who are dishonest and fraudulent and off of the book, so to speak, rather than spending a lot of time on this issue. For my part, from the private law practice, malpractice carriers will absolutely want to know about it. And I think that that will be problematic, because as we saw from the statistics yesterday, you know, of the 15 or 16,000 complaints, you know, 13 or 14,000 are just not pursued without any action. So I don't see any upside here, and I see lots of downside in terms of taking away OCTC's resources that are better spent elsewhere. So that's my 2 cents on this. Thanks.
Trustee Buenaventura.
Mr. Cardona, can you tell me if complaints, let's say, are lodged against an attorney and no action is taken, let's say an attorney gets several of them and no action is taken, are you going to bank those complaints such that if it does come to where action is taken, you're going to be able to say you've had 5 complaints of the similar nature, and that puts that person, that attorney, in a position of saying, well, you didn't tell me about them. I didn't know about them. So how am I supposed to remediate or correct my behavior if I don't get any notice of it? So I guess what I'm asking is, will you be using complaints against the attorney in a future, let's say, disciplinary proceeding, even if they didn't know about it?
We wouldn't be using those complaints in the disciplinary proceeding. In other words, they are closed matters, so we wouldn't be using them in an actual disciplinary proceeding. However, we do consider those in making decisions as to whether to move cases forward to investigation. So for example, let's say that we've had someone who has had 4 or 5 complaints that all relate to how they've handled their client trust account. We may have closed each one of those as we move forward, concluding that they have no facts, and then we get a 5th one. We may look back and say, okay, we've had 4 of these, we closed each of those, now we've got a 5th. We may decide that we may give the benefit of the doubt to moving that 5th one forward to investigation based on the fact that we've had this history that appears to suggest there's something going on with their management of their client trust account. So that may weigh into our investigatory decisions, but ultimately, when we get to a disciplinary proceeding, the fact that they've had 5 prior closed complaints, just as in criminal cases, the fact that you've had 5 arrests, we wouldn't use that in the disciplinary proceeding, but it might weigh into our consideration as, should we move this forward to investigation? Does that answer?
It does. Thank you.
Anyone else? Mr. Cardona, it's seems like this might be a good time for us to resolve the questions you've just asked. We've already had one trustee express an opinion. Trustee Tony wants to speak, please.
Thank you. I appreciate Mr. Cardona bringing this up, because it's an issue I have been bringing up for a while. And it's in the spirit of what, you know, part of what we want to do is not just to prosecute attorneys for wrongdoing. I think part of our goal is preventative. And I'm thinking about the preventative aspect. of how do, are there early warning signs where we can, and in some ways that the client trust account program that we've come up with, that is in a spirit of preventative action. That is the spirit. And I'll just say, insurance companies can want anything they want. We don't have to give them nothing we don't want to give them. Okay, I'm just saying. So they can want stuff, but
yeah, I'm gonna actually offer a different perspective on that, because it's not that. I think what we're saying is it's not going to be incumbent on the board, on the bar to notify the insurance companies. It's incumbent on the licensee and the insured to notify the insurance company if they're aware of complaints against them. I think that's the issue.
Okay, then we may need to seek a change in statute, okay, that protects the confidentiality of a closed complaint. Okay, there are solutions to this, okay, and I think it's the kind of thing that is worth talking to the insurance trade associations about. If part of what our goal is to reduce the misconduct that results in their payouts, in their insurance policies being tapped, sometimes insurance companies can be persuaded to support something. So I understand there are certain obstacles that are real and have to be addressed. I think it's important for, if I were an attorney, I would want to know when people complained about me, even if it's not found to be actionable, because I would want to be thoughtful about what am I doing, what can I do to minimize the dissatisfaction? What can I do to provide better communications, better customer service, so that I get less complaints. So that's my opinion. I think this is an important thing, an important tool to protect the public, and it's early intervention.
So right now we do that on a discretionary basis. In other words, we issue what are called resource letters, which I've given you the outline that I did previously of our non-public resolutions. One of those is a resource letter. We do issue those in all bank reportable actions, which is basically when a bank indicates to us that there's an insufficient funds check on an account, because the attorney will have had notice of that as well, so we do a resource letter there. We do it on, in other situations, discretionary, based on a consideration of all the circumstances, including the respondent's prior history of complaints and other things, and if that suggests to us that there is a concern that absent guidance, there will be further misconduct. So right now we do that on a discretionary basis with that in mind. This would be a shift to basically doing that in all circumstances, which poses a number of issues, not the least of which is it would ultimately require us to expend additional resources in drafting basically a second closing letter to a respondent to the attorney in every single complaint. I don't think that would be a non-minimal additional workload for us.
Okay. Sounds like you're agreeing with Trustee Good's commentary on the resources. Any other input on this issue? So if I could ask the general counsel, I mean, Hylin, I'm sorry, I didn't see your hand.
Oh,
Please
it's
go ahead.
okay.
Trustee Chen.
I just wanted to say I agree in many respects with what Trustee Tony shared. I do think it's worth undertaking this look. I thought that the pros and cons that were provided by Mr. Cardona in the materials were quite thoughtful and warrant further analysis. I noticed that there were a number of items that talk about further research needed. I mean, we've focused on this, what do malpractice carriers do, but there are other items about further research being needed as to whether there is inconsistency with what other jurisdictions do, with whether this aligns with what the Department of Consumer Affairs disciplinary boards do. I think it would be beneficial to get that further research. I'm focused on the fact that we need to be rebuilding trust with members of the public. Given everything that we learned through the Girardi investigations, we need to be establishing accountability. I know that non-public private reprovals, as Mr. Tony noted, has been a source of that lack of trust. And I think it's worth looking into these issues. And to the extent this is just OCTC seeking guidance, my guidance would be, and interested if other board members agree, is to pursue this path.
Trustees, do other board members agree? I do agree with Trustee Chen, actually, in terms of getting the further information. Any other perspectives? It sounds like Trustee Tony would also, yes. Trustee Noel, please.
No, I'm saying I agree.
Okay.
So that's 4 or 5 of us, I guess.
All right, so I will take that as guidance that the sense of the board is that we should, on the first issue, do some additional inquiry and stakeholder outreach and return. Now, the second issue, which I think Trustee Chen has moved to, is the issue as to whether...
Before we get there, I apologize, Mr. Cardona. 2 hands went up, Trustees Good and Sowell. Is it still on the first issue? Or were you just raising your hand to say, okay, I agree with Trustee Chen? You're still on mute, Trustee Good.
Thank you, Chair. I was just going to comment that the report of the ad hoc commission on the disciplinary system will be in front of the board in September, I believe. And it might be useful, frankly, to table this discussion until then, because there will be some significant items to discuss there, which I think will persuade many of you that this should not be looked at. Maybe not, but I would just suggest that maybe OCTC not engage in this work until we've taken a look at that stuff, because I think that would be more efficient. We can take this back up in September. I don't think this is a public protection issue at all. So that's one suggestion. Thank you.
Thank you, Trustee Good. Trustee Sowell.
You know, the only thing I was going to offer is that George, there's an awful lot on this agenda that adds to the workload of OCTC, as well as we know other things that are afoot with various things that are happening both externally with OCTC's workload. And so I'm sure you have some sort of a work plan, but I think it would be good, at least for board members to have a better insight in terms of some prioritization. Because I think it would be helpful for me, one, just to not only see the comprehensiveness of everything it is that's on the plate here, but also what we may be adding to.
So I'll respond to both of those. I think there are 2 ways we could go. So here's my suggestion. On the first one, the notice to everybody, I tend to agree. I think it might make sense to put that off until after September. Because I think this will require significant amounts of work to gather the information in particular, and B, if the board were to implement it, it would require significant additional work from OCTC. And so it might make sense to put that off until after September, when we have a better idea of what's going to be recommended by the ad hoc commission. The second one, however, whether the board should consider making all discipline public, that is essentially doing away with non-public private reprovals and having what are essentially only public reprovals. I think it might make sense to take a look at and come back in September, since I think that will mesh with some of the stuff that the board is going to be considering in connection with the ad hoc representations and might make sense to consider as a package with those, or at least have the information to consider that as a package with those. So I'll give you my recommendation.
I was going to say, if that's a recommendation, I think it's clear to me. Trustees, are we okay with following the Chief Trial Counsel's recommendation? I don't think we need a vote on this. I mean, I'm looking around the screen and the table, and I think it's safe to say you've got that.
And the reason I'm okay is because the earliest we would take action would be July anyway. And so we're talking about one more meeting, and
Yep.
I think that's fine.
Wonderful. Okay. Good. Thank you. All right. Let's get back to the agenda. I see that we have quite a few people still online with us. I know we had people here in the room yesterday on the Jenny Commission item. And so if there are no objections on the board, I'd like to go to that item and get it taken care of before we break for lunch. Trustee Noel, your hand has gone up. Is that you're on mute, sir?
Thank you, Mr. Chair, for indulging me. But what I wanted us to think just for a minute or less about how implementing or voting for number 2 today would help our efforts towards a fee increase. I'm thinking about asking that. It would be nice to be able to say, look what we've done and what we're doing. Stop punishing us and let's get on with it. Give us money.
Yeah, no, I think it's a fair point. Thank you for bringing it up. And Mr. Cardona is coming to the hot seat again. I don't know if that's because you have something you want to say, or if you don't necessarily yet, what I would suggest is that maybe we take up that particular question as a part of our legislative priorities discussion later. I'm assuming that would sort of make sense in the context of that discussion. That'll be okay with you, Greg?
Yes, absolutely.
Okay, great. Thank you for coming back, Mr. Cardona. All right, if I could get some help, what number is the Jenny number? 703. Okay.
And Chair Duran, I apologize for interrupting. I do have a pre-existing conflict today starting at noon, so I'm going to drop off now and rejoin after my meeting ends.
Okay, thank you, Trustee Chen. Next is on the agenda is to approve, having returned from public comment and received quite a bit of public comment yesterday, proposed amendments to state bar rules related to the Commission on the Judicial Nominees Evaluation, in-person candidate reviews. These are rules 7.52 and 7.60. This item is being presented by Deputy Chief of Programs, Bridget Grammy. Welcome back.
Thank you. I think, Mr. Stalling, did you want to start off on this item?
I'm okay starting off or following up here. So yeah, I just want to thank all of the commission members, both current and former, for giving your significant public comment on this area. I think it really speaks to your level of dedication and speaks to the care, continued care that you have for Californians, and to ensure that we at the State Bar are doing the best possible job that we can, certainly through engaging the people who are doing the good work day in and day out. I think that's something that as a trustee I really appreciated hearing about. I know that Trustee Shelby and I have put in a significant amount of work on this, as has staff, and hearing some of the comments about State Bar staff's engagement with Jenny, and about, I think anytime you have two different positions, I think there's perhaps differing of opinions on how much dialogue there is and the fruit of that dialogue. But I did want to give staff an opportunity to speak to some of the issues raised in public comment both written and in person, and to give us as a board kind of a path forward, recognizing that there is important work, incredibly important work to be done through Jenny, but we also have to balance that with very real and stark realities of budgetary issues and a legislative mandate that when you have competing priorities, we have to choose the one that promotes public protection. And in my view, that's the discipline system. So wanted to hand it back over to staff to talk about, I think some of the issues that have been raised in public comment.
I want to clarify, Mr. Stallings said that we've been working on this issue and we have not. And so I wasn't really quite sure in terms of, yes, we've been working as appointment liaisons as it relates to the Jenny Commission, but I have a different viewpoint in terms of this and this item. And so I'm looking forward to us having the discussion here today. So I wanted to clarify that on the record. Thank you.
Thank you, Trustee Shelby. Okay.
Well, I think maybe just so we could accelerate getting into the discussion, staff's recommendation, as written in the memo, is for the board to adopt amendments to Rules 7.52 and 7.60. 7.52 relates to interviews, 7.60 to meetings. As indicated in the item, staff, based on the feedback that we received, I personally received from Jenny, is no longer recommending any remote meetings. So 7.60, the rule related to remote meetings, that amendment is not needed at this time. So a path forward would be for the board to table that rule amendment. 7.52, the modifications that are requested would allow for the continuation of remote interviews. Staff is recommending that the board adopt that amendment. I think some of the data that Brandon is referring to is the data that's in the agenda item related to the impact of remote interviews. And as alluded to in the item, we've also done a number of other analyses of the impact of various changes in Jenny. But those changes are not on the table today. So I think if you just look at the data around interviews, there certainly isn't data that suggests that there is a negative impact on candidates of color, women, or women candidates of color, which are some of the concerns that have been raised to me. So I think that's staff's recommendation. The only other thing I would say is I was disappointed that in a lot of the comments, there was not an acknowledgement of all of the effort that staff has made to engage with Jenny. That goes from Bridget and her multiple meetings with the former chair and vice chair of Jenny, as well as presentation and discussion with the commission. In the last 6 weeks alone, I have met with the leadership of Jenny 3 times. I sat for an hour and a half with the full commission. There have been many, many efforts to engage the commission that have not been recognized. That being said, here we are, and I do think that perhaps pulling one of the rules, making it clear there is no intention to pursue remote meetings, yet asking the board to support a continuation of remote interviews might be a path forward. And with that, happy to go to discussion, or if I left anything out, Bridget or anybody else.
Thank you, Ms. Wilson. I see that Trustee Tony has activated his mic. I think that means he would like to speak. Oh, I apologize. Okay. Any questions? Ms. Grammy, you want to add something?
Sure, just one thing to add on the 7.52 on the interviews. That is one area where the commissioners were not united in their opposition. We did receive, I believe it's in the item, I think it's 6 current and former commissioners did actually express support for that rule change. And a couple of them who had experienced both Zoom and in-person interviews noted in their public comment that they didn't observe a meaningful difference between the two, and in light of all of the budget concerns, the scheduling concerns, there's a lot of different things that we outlined in the item that, outweigh the pros in our view of maintaining the in-person interview. So I did just want to add that.
Okay. Trustee Null, your hand has gone up.
Yeah, I just have a question for Leah or really any person on staff. I'm confused about what I'm reading or what I'm hearing you saying. Um, are we saying that they have to be remote, or that they can be either remote or in person, and it's up to the candidate?
No, the interviews currently have to be remote, or they are remote, and under the proposal, the interviews would stay remote. We wouldn't add budget to support in-person interviews.
Okay, then that leads me to the next question is, I get the feel on this and in other venues that the Jenny Commission is special, that they get special treatment, that we ask all the others to take cuts because of our situation. And I don't know where they're cutting. And I just want to make sure that people think that that's fair and appropriate because Jenny is special. That's it.
Well, to be fair, Jenny previously had been funded, so they meet Friday and Saturday. Previously, they were funded to have 2 nights of hotel, so Thursday, Friday, associated with their Friday, Saturday meeting. They're this year funded for 1 night of hotel, so that is a change. That's a cut. They are, what you're referencing, I think, is the fact that they are the only group that is meeting 100% in person. The rest of our sub-entities, like the Committee of Bar Examiners, for example, 4 remote meetings a year, 2 in person. So Jenny is being most certainly treated differently than all of the other committees. But that is a cut. And then the remote interviews, that occurred, of course, because of the pandemic. And so we haven't brought it back. The emergency order related to the pandemic is gone now. So the rule needs to be amended to continue to allow for the remote interviews.
Thank you.
Okay, so I'm sensing that maybe we want to bifurcate the discussion and the decision. We haven't.
So I just have a comment because I did reach out to the chair. I wasn't quite sure if all of the board understood how Jenny worked. And so initially, and I think it's interesting, we've jumped into a conversation and we haven't even had the item presented to us. And so I'd like to point that out as well. I'm not sure if the full board understands how Jenny works. And so I think it would be great to level set this conversation before we go into making an opinion. I think that would be helpful. So if Ms. Wilson or Ms. Gammy could do that for the complement of this conversation, I think that would be great.
Okay.
Sure. You mean just how their operations, how it works? Okay. Sure. So basically, there's a statute in the government code that obligates the state bar to review every candidate that the governor would like to appoint for a judicial office. And so we have every 90 days, we've established the Jenny Commission, it's 38 members, and they have 90 days to look at a list that the governor gives us. That list right now has varied, but it's around 30 candidates per cycle. And then the candidates are, the commissioners are assigned by the chair to usually in each cycle investigate 2 different candidates. So they send out emails to various people to get feedback about it. They call, they do investigations to find out information about this candidate. They interview the candidate as part of this investigation cycle, and then they write a report with a recommendation. There's usually a 2-person commission, two-person team, investigative team per Superior Court candidate, and 3 people, including a public member, for the appellate court candidates. And then they write their report. There's always a lead investigator. They make their recommendation about what the qualification of the candidate is. So it would be exceptionally well qualified, qualified or not qualified. And then they come to the meeting, they present their recommendation, the report at the meeting, and then the commission has a vote and they decide whether, on the final recommendation, which we give to the governor. But for those who are have a not qualified rating, those candidates have the opportunity to seek a review in the RGENI, the Review Commission, and then that's a separate process where the RGENI, which Mr. Cisneros and Mr. Broughton serve on, they review the commission's work, and sometimes they might rescind the order and send it back, or sometimes they might confirm it. So that's very high level, but that's the gist.
Can you talk about the time that's involved in the learning curve that's involved as it relates to the Ginny Commission as well? Because I think that's important too.
Yes, it is a lot of work.
If you can put that in the concept of time, that would be great.
Sure. I think I don't have it right in front of me, but I think it averages maybe 40 hours a month, I would say, on depending on the complexity of the candidate. It is a significant amount of work. We also spend time as staff, and we have recently in this past year worked hard to improve the orientation process. So that when candidates come on, commissioners come on, they serve a 3-year term. We do an orientation where they learn how to do the investigations, all about the confidentiality that's involved, best practices. We put together a bunch of templates, all those types of things. So they are trained, and then they shadow a current commissioner before they take on their own role. So that's kind of the training onboarding process.
Sorry about that. And then last but certainly not least, can you also, and I know that there are confidentialities here as it relates to Ginny, but as it relates to ranking candidates, is it a situation where everyone one ranking emerges from the conversation with Ginny? If you could talk about that, and if you could also talk about what transpires with the interviews. And I think you touched on, last but certainly not least, you touched on an onboarding process and shadowing. How much time is required? If I were to be a Ginny member, how much time would I need to shadow you before I could join the full commission? I think that's helpful as well.
Okay, so for your question about the way that the final recommendations work, sometimes the commission, if there's 2 people on a investigating team, sometimes they may disagree about a rating, and so they may present to the commission, we have a split rating here, and then the commission might make a recommendation. Usually it's the majority rule that will be the final recommendation sent to the governor's office, but the governor does receive like a breakdown of what the votes were, so he would be able to see whether it was unanimous.
Excuse me, Mr. Chair, I think you were going to indulge.
With respect to the time on the shadowing, the way it works, I'm sorry, I just don't have the number of hours in my head right now, but the way it works is they'll shadow for a cycle, so they'll listen in on the investigation process with a commissioner, then they'll attend the interview and attend the meeting for the April meeting so that they see the way the whole process works. I don't know how many hours that includes, but it is a substantial training.
And last but certainly not least, once a candidate has been interviewed and people come together with the 38-member commission, how does that process entail? If you could just provide an overview of how that transpires.
You mean at the meeting?
An overview of, so there's a candidate, the candidate has been interviewed, what transpires next in terms of the 38 people that come together for those, I think, 3 days, 2 days, 2 nights.
Yes.
Thank you.
Sure. So the investigating team drafts a report in advance. They give it to staff edits, and then we post it on a shared SharePoint site so the commissioners can access the reports in advance, usually about a week before. And then when we come to the meeting, the current procedures are that the lead commissioner will read a summary of the rating, a summary explaining the basis for the rating, and then they will go into a discussion about it. And then take a vote.
Thank you, Trustee Shelby, for the questions and the refinement. I'm experiencing a little bit of deja vu because I remember Ms. Grammy going through this process. And I think it was in the context of the conversation of public member appointees to Jenny. And so maybe I had confused that conversation with the level setting that you're talking about. But certainly the refinement that you've added here, I think, is useful to the conversation, certainly complements the public comment that we received yesterday in person and in writing. So I'm hoping that the board has a good sense of the issues that we're talking about here, the time commitment from the commissioners and the staff. And again, to echo what I said yesterday, thank you to everyone who takes significant portions of their life to achieve this important objective on behalf of the governor and the state of the people of the state of California. Mr. Cisneros.
Thank you, everyone. And I just want to thank Trustee Shelby for provoking that explanation. I think it is a unique and very special process that the committee undertakes, and the Jenny Commission does very valuable work. For the last number of years, I've had the opportunity to sit on our Jenny, which is the committee that reviews any applicant's request for reconsideration of the outcome that they received from the Jenny Commission. Certainly the number of instances of that is very small compared to the volume that the Jenny Commission handles. It's only a handful per year, and we meet only a few times per year. I think our committee has five members, and we have a process that's a bit similar to the Jenny Commission. Once we receive a case, one of the 5 members is assigned that case, and we review all the material of the put forth by the Jenny investigators, as well as the results of their deliberation and their voting outcome. The assigned member of Jenny does a similar write-up that the Jenny investigators did, and then we have a similar conversation in our Jenny meetings, where we decide to, as you said, stated, to either uphold the decision of the Jenny Commission or reverse the decision of the Jenny Commission. That all being said, I have nothing but incredible praise and respect for the work of the members of the Jenny Commission. They take on an incredible volume of work, and I think it's the intention of the governor and the governor's office to increase the number of appointments that they are trying to complete, and so that work is in the process of growing. I will say, so I respect their request for their desire to hold in-person meetings. This debate is at times certainly very complicated and even intense, and certainly understand how they can value the ability to do that in person. With respect to the candidate interviews, I will say that I've served on our Jenny long enough that I was around before there were remote candidate interviews. And in that situation, the interviews were done in person, and they were memorialized or captured through the use of an audio recording. And the audio recording, like all the other materials for each case, was delivered to our Jenny in every time a case was forwarded to the our Jenny team. And so we on our Jenny had only the audio recording of the interview, which is a very valuable piece of evidence when reviewing any of these candidates. We only had an audio. Of course, the pandemic hit, everything went remote, and then all of the interviews were done using Zoom. Because of that, then when cases came to our Jenny, we now had a full-blown live in color video of the entire interview. And I think it certainly speaks for myself, and I would imagine for most, if not all, of the Jenny commissioners, that we find it very valuable to be able to see the entirety of at least one candidate interview. Sometimes there's more than one, depending upon the case. And the ability to see as well as hear has been very valuable. I understand that Zoom video is not currently shared with Jenny commissioners when they're debating the case. I'm not sure if that couldn't be changed going forward. If it could, I think it could be very valuable for everybody to see the full video interview of the candidate, if folks would find that helpful. But that's why I believe I will support the continuation of the practice for both in-person meetings for now, of the Jenny Commission, but remote, not in-person interviews, because I'm pleased by the evidence that shows it does not appear to change the outcome in terms of candidates' success, no matter their identity. But also, I believe, because of the upside of the greater integrity and information that it delivers. Thank you.
Thank you, Trustee Cisneros, and thank you for your service on our Jenny, along with you, everyone. Does anyone, Mr. Tony, please?
Thank you. I want to start off with some clarifying questions. I know I very seldom have questions, but this is an actual real question. I'm trying to get the understanding that if what we're being asked to approve today is a continuation of current practice, which is remote interviews, how does that save the bar $50,000 to $100,000?
If it's written that way, then I think the item, I'm not looking at the item. What saves the bar that money is having the remote interview. So going back to in-person interviews would be a cost. The item as presented is status quo. It's not a cost-saving item.
It's avoidance of a future cost. I'm just trying to get an understanding.
Yes.
Okay. Thank you for that clarification. But I do have some comments to make. My part of my preference here, if it were up to me, I would have appreciated the chair of the Jenny Commission to have been present to answer some of our questions. That's just my preference, okay? I did appreciate Josh Pertula, the chair of the Blue Ribbon Commission, being here earlier this morning to answer some questions. I want to go to Trustee Noel's question, which is an important one, which is what makes Jenny so special that they should get special treatment? That is a fair question. And I'm going to give you my view of what makes them special. And that is because the way I look at it, judges are incredibly powerful individuals, and they hold within the palm of their hands the fates and futures of individuals, families, communities, and in some cases, society. And I really think that the ranking of judges as part of the selection process is incredibly important. I am aware of the State Bar's core mission to protect the public when it comes to the practice of law, and particularly attorneys. Statutorily, the State Bar was given this authority also, and this responsibility by statute. I'm not happy that we're not being adequately funded. Melanie and I have been working with staff to have meetings with the governor's office to request additional funding. So, it's not, and just, doing what we can here. And so I'm going to talk about, and we got a lot of comments on this, a lot of comments from current and former Jenny commissioners. That's a lot. I mean, that weighs heavily on me. And I'm going to bring up a topic that's not on the agenda, but it has to do with, my experience is I'm going to talk about the meetings and the previous cuts that were made. The cut from 2 nights to 1 night. I know how much I appreciate as a trustee coming in the night before a 2-day meeting, of coming in Wednesday night and being ready to start Thursday morning, okay? That makes a big difference, because what it means for me is I don't have to get up at 5 o'clock in the morning. Maybe some of y'all are morning people. I am not one of them. But seriously, there are a lot of people who have to travel before they get to the airport, then have to fly, and you try to grab breakfast, be ready for a 9 o'clock meeting. And you know what? When I do that, and I have to do it, I arrive at meetings tired. I'm already tired at the beginning of the meeting. Maybe I'm unusual, but that's me. And there is value. Morning time for most groups is the most productive time of the day. And the longer you get in the afternoon, like yesterday, I'm using my experience, I know that the tireder I got and the more I had to work harder to focus. Okay, in the morning I don't have to work very hard. If it's 4 o'clock in the afternoon, I got to work hard to focus. Okay, and so I guess I believe there's a lot of value for a 2-day meeting having 2 nights. And I guess what I would like us to consider is this $50,000 or $100,000 impact. If it were up to me, I would let the Jenny Commission decide. Where do you want to put that? Do you want to put it in in-person interviews? Do you want to put it in an extra night? And, we've got a lot of other things that have a lot of cost. We approved in our consent agenda, we approved over $700,000 of needed expenses. There's another agenda item later that has to do with the whistleblower policy and shifting that over to the State Department of Justice, State DOJ's office. That has a cost of between $50,000 and $100,000. And I would say, weighing the two, I'd rather have that go to Jenny now and postpone the implementation of the whistleblower portion, contracting out until the bar gets adequate funding. So those are my thoughts.
Hold on a minute. Thank you, Trustee Tony. Trustee Sowell's hand went up, and then Trustee Buenaventura.
I just had a quick question, and that is, as Mr. Tony and others have indicated, we received an awful lot of commentary about this particular item, and it was born out of our efforts to look for some cost savings. And if I recollect to some of the comments that were made yesterday, particularly to I think is it Mr. Fu, who may have made a comment, public comment yesterday, where he indicated that he felt that there were places that we could look for additional efficiencies with Jenny, and would be happy to sit down and talk to the staff and the board about where he thought those might be. And I just wonder whether or not if we've explored everything it is that we need to explore with Jenny related to efficiencies.
I spoke with Mr. Fu as well. chair and vice chair, it might have been the former chair and vice chair, gave us a couple of suggestions, I want to say a couple of months ago now, which we did explore. We provided that information back to them, sort of, ideas they had for hosting the meetings in different venues. So we've done a little bit of that. I think Mr. Fu's idea yesterday that he shared with me was that we would stop booking the travel through Concur and that the travel costs would accordingly go down. I'm sure there are other ideas. We are not looking today to extract further cost savings from Jenny. We're merely asking the board to adopt a rule that would allow remote interviews to continue as they have been since March of 2020. So if the thought is to sit down with Jenny to figure out how to bring interviews back in person or how to fund 2 nights of hotel, then perhaps that is a conversation to be had. If the board would like those ideas to be generated in a cost neutral fashion, that's one thing, or not cost neutral, that's another thing. So I just want to make clear we aren't trying to extract any further cost reductions. I'd also like to say on the 2 nights of hotel, the Jenny, as I understand it, the current, and Bridget can correct me, but the meetings do not take 2 full days. So what we have suggested to the leadership is to start the meeting later on Friday to accommodate people coming in. And as I understand it to date, that has not occurred. And it may be, as you said, Mark, because they don't want to start a meeting at noon or 11. But I just want to put that out there. The meeting does not have to start at 9 a.m. on Friday. So, happy to have further discussions or have board members have further discussions with them. But I think we need to be really clear. We aren't trying to save more money now. We just want to continue as status quo.
If I could just sort of, the genesis of my question is not what it is in terms of relative to the item before us in terms of what it is that you just indicated, Leah. It was just simply to try to ascertain whether or not there had been other conversations that had taken place relative to efficiencies.
The two suggestions that were raised with us is hosting the meetings offsite at law firms or hosting the meetings in hotel space. And the law firm item, I believe, I asked OGC, perhaps Aline remembers, to weigh in, just the thought that perhaps that might not be appropriate, the look of that. And the hotel space is more expensive than what we're currently doing. So those two, I specifically know that we explored.
Thank you.
Trustee Buenaventura.
Thank you, Mr. Chair. I had a question about the issue to me is about whether or not we should be eliminating these in-person interviews. And I have a question procedurally about how that is done and in terms of the cost. So my question is, when a candidate is going to be investigated, I'm assuming then, that's what you're saying, 2 commissioners are assigned to investigate. So is it the case that as far as who those 2 commissioners are, the geographics of where they are located should coincide with where that candidate lives or is seeking the judicial appointment to? So is there an effort made to just have those commissioners who live or work in the same area be the investigators for that candidate?
I believe, although to be honest, since I've been staffing it, it's been remote. We've been in a remote situation, but my understanding is the practice was to attempt to do that, but it is very hard to have, there are people that have to recuse out, for example, of certain candidates. And so it is a pretty tricky business to try to assign everybody to candidates. I believe they do make an effort to make the geographic location as close as possible, but the way it works is the interviews would either be here in the LA office or the San Francisco office. And then the candidates fund themselves to get to either of those offices. And just depending on where the commissioners are, they may or may not have to travel, just depends. I mean, fly anyway.
Ray, I wanted to clarify because you said something that made me think we weren't clear. The interviews are all remote now, right? So it's been that way for 3 years. So I think you understood that.
Oh, so the interviews are all remote for the last 3 years?
Yes.
I see.
We did have one, I just want to make sure we're clear. There was one cycle in April of 2022 when they went back to, they tried to go back to in-person interviews, but there were still so many issues with COVID, and then they would have to cancel at the last minute. It was just not working. So they went back to remote. So there was one brief cycle where they did try to go back to in-person, but for the most part, for the last 3 years, it's been remote.
Thank you. Trustee Cisneros, please.
Thank you, and I very much appreciate this conversation and description of what's going on. I do want to add, though, to make sure, again, to Trustee Shelby's point, that everyone understands what's undertaken here. There have been a lot of comments from, obviously, current members of Jenny and former members of Jenny, and I've actually spoken myself to at least 2 former Jenny chairs, and then some more in person yesterday, and a number of other folks. I do want the board to understand that the initial agenda item was different than what's being proposed right now, and it was that further difference that definitely involved creating a lot of the comments that we are seeing. Remember, the agenda item said it was to change 2 rules, both the rule that said interviews had to be done in person and the rule that Jenny meetings had to be done in person. I appreciate staff's new proposal that takes the latter out of the item. And so if that had been the way it was initially in the agenda, I'm guessing there might have been a difference in terms of the comments that we've seen. And I think Ms. Grammy talked about how there was even support for that in some of the comments. So I just want to make sure everyone understands that people who commented, by and large, until they were notified, which was only in the last few days, if they heard it, that there was a change, we're commenting on the more full change of two resolutions, not just one. Thank you.
Please, Mr. Tony.
Are you suggesting that that this has been updated since Monday? Because what I downloaded was Monday, and it looks like it has 2 items here.
No, I think what he's saying is in the item, staff is recommending board adoption of 2 rules, one related to interviews, one related to meetings. Today, when I spoke, I suggested that staff would withdraw the recommendation regarding 7.60.
Got it.
In the item, however, it does say that staff was no longer recommending any remote hybrid meeting. That is written in the item, but we still were requesting the rule change nonetheless. Today, saying let's just withdraw the rule change. Take it off the table on the meetings.
Thank you for clarification. I'm trying to follow.
Trustee Stallings and then Trustee Shelby.
I was going to move the item, but if there's further discussion, I can wait.
So,
please.
Did you want a second or I just want to, there are a couple of things that are running through my mind. We just had a very extensive conversation on BRC. And in that conversation as a board, we decided to advance something to the Supreme Court because we respected the work that the BRC completed, and we had a caveat to that. And so it's interesting to me that in this conversation, and I do appreciate the overview you provided, I think it would have been wonderful to hear from leadership in Jenny in terms of the Jenny process, because I realize as a board, I've never had the Jenny experience. I've had the honor to appoint people to the Jenny Commission, but I've never had the experience of what they go through. And when people show up and have that level of public comment, It seems to me that if it's been withdrawn, whatever the case may be, but it seems to me if there was an opportunity for the Jenny Commission to provide a recommendation on where cost savings should be, and I understand that this was not a cost savings issue, but when you look under fiscal personnel impact, it says here the cost is estimated to be between 50 and 100,000 annually. And so there's a cost impact that was in our meeting materials. I have been very vocal that I think we get the best of each other when we sit in a room and have a conversation, because we get the opportunity to read body language, we get the opportunity to dialogue, we get the opportunity to pull people to the side. And I think that's valuable as it relates to the spirit of the discussion. I also think it's important, though, when we have people come in and present, and if there's some confusion, that should be addressed with the group, because everyone's comments were really similar. And so it appears that there is a direction that this board is going to take. I don't have a crystal ball, but I would offer this. If it's a situation where you're looking to, because this item does talk about fiscal impact, why don't we allow the Jenny Commission to make the recommendation as it relates to any cost savings? And then that way we can either approve or disapprove the recommendation that comes from that body. I think that gives them the opportunity to engage in conversation. From the discussions that I've had, and I've certainly had multiple conversations, the commission was not consulted. They did not have an opportunity to have a dialogue and a discussion. So I would offer and ask if there was an opportunity to table this, if there was an opportunity to postpone, that we postpone it until the July meeting. And then in July, we can make a decision as it relates to how we proceed and move forward. I would also offer this. At our meeting in July, I think it would be wonderful to have Jenny leadership come and provide a perspective. So as we make a decision, we can make a very robust decision in a comprehensive way. And so that's what I would like to propose today, is that we postpone the item until July.
So I hear a motion to table this item. Is there a second? Or rather continue, if I may, Trustee Shelby, continue to our July meeting. Is there a second on that motion?
I second.
Before we engage in a debate, I will just say that I found it very valuable to listen to the chair of Jenny. I've had conversations with the previous chair of Jenny. We heard certainly from many current and former commissioners, and so I don't feel like I'm missing that input. I understand that we have a difference of opinion on that, it sounds like, and I respect what you're saying. Any discussion on the motion to continue?
I would just like to clarify something because it's been raised a couple of times. The fiscal personnel impact in this item says if the board does not adopt the proposed amendment to Rule 7.52 and the commission reverts to in-person interviews, this will result in a cost. So I just want to be clear, that is the cost. The cost is associated with not adopting the rule change. So I just wanted to clarify that.
Thank you for the clarification. If there's no discussion, can we take a vote on the motion to continue this to the July meeting?
Mr. Chair, if I could just briefly address some of the concerns of Trustee Shelby. So, we've heard from staff. The staff has engaged Jenny. I engaged with Jenny yesterday. I think there's value in continuing to engage in some of these other issues, but my understanding is that the issue of the in-person interviews and whether they can continue or not is a very pressing matter. And so I think we as a board can move on that today and then also respect Jenny leadership and continue to dialogue with them on cost-saving measures. So I would support voting no on the motion to table and then supporting a motion to move this forward as staff has articulated.
So if I could just get some clarification from staff on that timing issue. Jenny's next round of meetings is in June?
Yes, so their next meeting is in June. The investigation is going on right now for that meeting. And then the next meeting would be in August. And so.
And the By the investigation, you mean the interviews?
Interviews are
Yes.
ongoing now, yes.
Mr. Chair, there was a motion and a second in relation to postponing the item. I just would love to see if we can move that forward. And
Well-
I'm just asking for additional time
No,
because I want
certainly,
to be
and I was asking for
respectful.
additional information as to the timing. So my
Okay.
vote on whether to continue this depends on whether the work of Jenny in June and July and August can get done, given a continuation to
Understand,
July. So,
understand.
thank you for the additional information. Anyone else? Okay, can we have the roll call, please?
Broughton, trustee Broughton has stepped away. Buenaventura,
I'll say aye.
Chen, trustee Chen has also stepped away. Cisneros,
No.
Good,
Aye.
Noel. Trustee Noel, I think you're on mute.
No.
Shelby,
Aye.
Soel,
Aye.
Stallings. No. Tony,
Aye.
Duran.
No.
Five ayes, 4 noes. The motion passes.
Okay, we'll see this item on our July meeting. Thank you, everyone. It is lunchtime, about the same time we broke yesterday, actually, so there you go. Same thing, half an hour, and then we'll reconvene at 1:15, please. Thank you, everyone. Okay, everyone, thank you for your patience as we wolf down a very quick lunch. We are recording, reconvened back in open session. I don't think we need a roll call. I'm gonna just move forward on the agenda. We're gonna still, this is still the Board of Trustees, or we're gonna go back to the Board of Trustees rather, meeting as the Regulation and Discipline Committee. And we are gonna start up with item 6-10, a request to publish Formal Advisory Ethics Opinion 2023-208, Ethical Obligations When Working Remotely. Seems to be a theme today. Could we please have, there you are. Good afternoon, Ms. Doherty. Welcome back.
Hi, good afternoon, Chair Duran. Thank you. I'll be very brief. So I'm here to seek approval of publication of proposed Formal Ethics Opinion 2023-208, which addresses, as you said, a lawyer's ethical obligations when working remotely. The opinion was developed and approved by COPRAC after 2 rounds of public comment with minor modifications responsive to those public comments. Very briefly, the opinion just advises on a lawyer's ethical duties under the Rules of Professional Conduct and the State Bar Act, and that those duties apply when working remotely. And the lawyer must implement reasonable measures, policies, and practices to ensure compliance with those rules in the remote environment. I'll just note that the opinion does not substantively address remote work from another state on either a temporary or permanent basis. And that's because in 1991, this board issued a resolution that prohibits COPRAC from addressing matters regarding the unauthorized practice of law. I just wanted to bring that to your attention because it's possible that staff will likely request the board make changes to that limitation on COPRAC in the coming months. As you've heard throughout today and yesterday, remote work has certainly changed everything. And so allowing for COPRAC to advise on such issues may be useful for attorneys. In the interest of time, that's all I have. So.
Okay, thank you, Ms. Doherty. I'm glad to hear that you're going to ask the board to revisit that issue. Certainly, it's been a long time. Trustees, any questions or comments on this proposed action? Okay, we have the resolution coming up on the screen. I will give you a second there to take a quick look at it, and if it looks good, may I have a motion?
So move.
Motion by Cisneros.
Second.
Second by Noel. Can we have the roll, please?
Broughton,
I have a question, please. It'd be useful, when we have these resolutions that just say as an attachment A, or here are the numbers and stuff, it'd be nice to just have a quick explanation of what this does.
Okay, it's been noted by staff. Trustee Shelby, okay. No other questions. We'll continue with the vote, please.
Broughton, not present. Buenaventura,
Aye.
Chen, not present. Cisneros,
Aye.
Good,
Aye.
Knoll,
Aye.
Shelby,
Aye.
Soel,
Aye.
Stallings, Tony,
Aye.
Duran.
Aye.
9 ayes, 0 nays, motion carries.
Mr. Chair,
Yes, sir.
this is Arnie. I'm not in the room there, and you may have already done this. But I know we've been bouncing back and forth on the agenda as rad as, would you mind maybe just articulating what items we still have left before us?
Not at all. I believe with our action on 60-10, we have completed the RAD agenda. Item 701 was the BRC, that is done. Item 707, and I'm not going to ask about the numbering, I'm just going to.
You need to do all these admissions, 702.
Yep.
704.
Okay.
No, 704 moved to consent, 702.
So left to consider, trustees, are 702, 703.
No, you did 703.
Oh, thank you, sorry. 702. We did 704 on consent. So we've got 705 left, 706,
All the rest of them.
708, 709. When we get to 709, there will be some recusals as required by our conflicts of interest rules, 711, 712, and then back into closed session. Okay. With that, let us kick it off with 701, please.
702.
702. Sorry, folks. This is a request to circulate for public comment proposed amendments to the admissions rules regarding examinations and moral character for out-of-state applicants. These are rules 4.41 and 4.62. This item is being presented by Program Director Tara Clark, although I see Ms. Doherty on the screen. Okay. We'll wait for Ms. Clark to get promoted. Good afternoon and welcome. It looks like Christina Dole is with us as well.
So good afternoon, everyone. Thank you for having us and just confirming that you can see the PowerPoint screen.
Yes, we can.
Yes.
Perfect. So thank you again for having us today. As you may recall, we brought these rules, or we've started the admissions rules and revisions process, and we brought some of them forward in November. You'll hear about those later today. So these are our next areas that we're going forward with today. So you'll hear about examinations rule 4.62 and moral character rule 4.41. I'll hand it over to Christina.
Thank you. Next slide. So Rule 4.62 requires that materials be returned to applicants within 60 days of the release of exam results. However, there is a statutory language that states that the materials must be given back to the applicants within 4 months of the release of results, and that the applicant may inspect their papers at one of the 2 state bar offices. Back in 2019, admissions had stopped mailing the applicant answers back to via USPS mailing back to the applicants. And so we're asking for State Bar rule to be updated to reflect the current practice of posting the exam results on the AIMS applicant portal, which gives applicants a quicker access to their exam materials. They're able to print, save, download their answers, and they can do that immediately upon the release of results. Tara?
Thank you. And so, as you may recall, a positive moral character determination is one of the requirements for admission in California. Currently, Rule 4.41 prohibits out-of-state attorneys who are currently disbarred, suspended for disciplinary reasons, or otherwise not in good standing for disciplinary reasons from even submitting an application for determination of moral character. So this means that they might be able to sit for, pass the bar exam, but they cannot be admitted until they cure the issues in their home jurisdiction. And just wanted to briefly point out that this specifies disciplinary reasons, because if someone is suspended for administrative reasons, for example, not paying their dues on time or missing CLEs, then they can still apply. So the modification.
I'm sorry to interrupt you. Trustee Shelby has a question, please.
Yes.
I'm not aware of what moral character is, so if you can provide a grander context before we get into the rule, that would be helpful.
Of course. So the moral character determination process, essentially, it's the in-depth background check we do to ensure that an applicant meets the good moral character requirement for admission to practice law in California. And so all of the applicants for a full admission, as well as the applicants for several of our special admission programs, for example, our multi-jurisdictional practice and foreign legal consultants, they must all submit the moral character application, be granted a positive determination before they can be admitted. And so this is one where this is the only prohibition we have on folks that are not able to submit an application, are these group of attorney applicants in these other states.
And just a question, it's an application process? Is it a conversation? I'm just not familiar with it, so I'm just trying to put it in context, please.
Of course, please just ask if there's any more detail needed. So it is an application that the applicant submits. It goes through our staff review process. If it is not able to be cleared on a paper review, the applicant might be invited to an informal conference with staff, so then it is an in-person discussion. However, the majority of the applications are approved just based on the paper review.
And I imagine once you go through this process, you don't have to go through it again?
So positive determination is valid for 3 years. If the person is not admitted for some reason, maybe they've moved out of state, decided not to seek admission, haven't been able to pass for the exam, they can submit the extension application. It's about half the cost, and the questions much less intense. They just have to answer anything that's happened since the last application. And then that would again be good for 3 years once they're granted a positive determination.
Thank you very much. I appreciate that.
Thank you for the questions. And so we go back to this rule, as I mentioned, so this is the only group of applicants that currently cannot even apply for a determination. So the modification of the rule, we are proposing that these attorney applicants are able to apply, which will give them the opportunity, and it'll allow California to make our own determination on whether whatever conduct resulted in their discipline or disbarment in the other jurisdiction should bar licensure here. And for the public protection aspect, we have included a rebuttable presumption that the applicant would have to overcome based on their standing in the other jurisdiction. And as we mentioned in the agenda item, this is in line with what the Supreme Court has said in the Mena case about how an attorney not in good standing in another jurisdiction is in a similar standing to a disbarred attorney here. Are there any questions on this? And I apologize if I'm going too quickly.
No, you're doing fine. Thank you so much. Any questions, trustees? Okay, seeing none. There's the proposed resolution. I'll give you a minute to absorb it. Any discussion or debate?
Mr.
Trustee
Chair,
Stallings.
I will move the item.
Motion by Stallings,
Second.
second Buenaventura. Can we have the roll, please?
Broughton,
Yes.
Aye.
Chen, not present. Cisneros,
Aye.
Good,
Aye.
Noel,
Yes.
Shelby,
Aye.
Sowell,
Aye.
Stallings,
Aye.
Tony,
Aye.
Duran.
Aye.
10 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. We're going to continue with Ms. Clark, at least, on item 705, which is a request to adopt proposed amendments to admissions rules related to moral character, law office study, and the practical training of law students program. And appendix, having returned from public comment and contingent on Supreme Court approval, this item will be presented by Ms. Clark, I think. Welcome.
Okay. Confirming you can see the PowerPoint again?
Yes, we can.
Perfect. Thank you so much. And so this is what I was mentioning earlier today. So at the November meeting, we did bring forth the moral character, practical training of law students, and law office study rules. We requested they be circulated for public comment as part of our admissions rules process and review. And so now they are returning for you. So with the moral character rules, these are the main themes of our rule changes. And I just wanted to point out a couple of the main ones just as a reminder. So clarifying areas of confusion for applicants. So we believe that the way that we've rewritten the rules, the abandonment process is much more clear. So an applicant is aware of when they do need to respond at which stage of the process, as well as when they may submit an extension application and the fact that they could submit multiple extension applications if needed. It's not just a one-time approval. As well as you can see, so although applicants do have a duty to keep us updated while their application for admission is pending until they've been certified to practice, they don't always do so within the requisite 30 days. So we are codifying a current practice of sending out a questionnaire halfway through that 3-month approval period, just prompting them to let us know if anything's changed. If they do fail to respond to that, then we can suspend the positive determination until we do get that response, just to make sure we have that full information prior to them being on the motion. And so with public comment, we received 11 public comments total. One of them was just an unrelated attachment. So of the 10 written comments, 6 agree with the proposal, 1 agrees if modified, 3 disagree. Of the 3 that disagree, 1 did not provide any comment. 1 essentially disagrees with the moral character process and believes that a Department of Justice background check would be sufficient. However, the committee believed that that proposal was beyond the scope of these rule revisions, as well as the moral character processes necessary for public protection. The other disagreeing comment mentioned prohibiting certain applicants from getting a positive determination based on conduct. However, that does not align with our current processes where there's no active misconduct in and of itself that precludes a positive determination. So as a result, there were no changes made by the committee after reviewing public comment. Are there any questions before I move on to the next section?
I don't see any questions. Please proceed.
Thank you, Chair. Okay, and so the Law Office Study Program, as a reminder, it is a path for licensure for those who may not be able to or wish to attend traditional law school for various reasons, such as competing priorities or financial constraints. So under California law, if the applicant completes 4 years in the program, passes the first-year law student exam, and is otherwise eligible, they may sit for the bar exam and upon passage, be admitted to the practice of law. And so here's an overview of the changes to the program. So essentially, the proposal seeks to modernize the program by acknowledging changes in the way that law is practiced and the technologies that we use today to interact with one another that may not have been around or utilized when the program was created. So specifically, the proposal will allow a significant percentage of the program to be conducted remotely. So it eliminates the requirement that the study program be conducted physically in the supervisor's law office or judge's chambers, and that it would be performed during regular business hours. Additionally, the proposal clarifies certain requirements, such as the proposed outline of study and the content to be submitted with, and the timeline for the semi-annual reports to be submitted. So for for the Law Office Study, we received 33 public comments. As you can see, the vast majority were in support of the proposal. However, in response to the public comment, the committee did make minor modifications just to increase flexibility, while still ensuring effective study program. So essentially how the LOS hours may be completed by changing from 18 hours per week from anywhere between 24 to 26 weeks to 72 hours per month for each 6-month period. They result in the same total number of hours. The other change was technical in nature, just to ensure that the changes under the rules will not inadvertently invalidate anyone who submitted under the current rules. And any questions on Law Office Study before I go to PTLS?
Yes, there is one question. Trustee Stallings, please.
All right, thank you, Mr. Chair. So in regards to the use of technology to accomplish these, the supervision of these individuals, is there any concern on part of staff or public commenters that the individuals going through this program would not receive proper supervision or have that required amount of input on their day-to-day activities if we move outside of like that physical location and allow them to accomplish some of these things via Zoom? I would assume you're talking about Zoom and other modalities like that.
Essentially, yes. So I don't believe so. There is a a requirement for the supervisor to work with the law office student for 5 hours for every 6-month period in person too, so they do get that in-person interaction. But some of the commenters actually wanted to do completely away with the in-person modality, hoping just for the Zoom. However, the committee and staff believed that that was still important just to have that hands-on interaction, but that the majority could be conducted remotely. And since there will be a specific plan of study in place, that staff will be able to monitor that.
Great, thank you.
Any other questions from the trustees? Okay, seeing none, May, you have one more? Yes, thank you.
Thank you. And so this is the other program that we're talking about today. Give me one moment, I apologize. So this is the Practical Training of Law Students, or PTLS, and it allows law students certified by the state bar and working under the supervision of an attorney to provide specific legal services to clients. The purpose of the program is to improve the training of lawyers by giving law students the opportunity to gain hands-on experience while ensuring the protection of their clients by having the students closely supervised. So the students learn skills and judgment that they'll need to practice law in a way that cannot be replicated in a classroom. And so here are the high-level overviews of the proposed changes. So most significantly, opening up the program to the LOS, so the law office students that we were just discussing, as well as LLM students, eliminating the requirement that they have successfully completed or be enrolled in a course in evidence or a course in civil procedure, and clarifying the program requirements and procedures. So for this program, we received 27 public comments. Again, the majority agreed with the proposal. While the committee did not end up making any modifications based on public comment, there were 2 that we'd just like to point out today. So there were 2 commenters who opposed the expansion of the program to LOS or LLM students. However, the committee feels strongly that for the same reason this program is a benefit to law students in traditional programs, it would also benefit those in the LOS program. And please keep in mind that the LOS program is a study program, which is very different from the practical experience that they would be afforded in the Practical Training of Law Students program. And similarly, the committee could not identify a valid reason to foreclose this opportunity to LLM students. And then lastly, the second issue relates to the elimination of the requirement to be enrolled in or have completed a course in civil procedure evidence. So there was a brief survey of the PTLS supervisors that revealed that while these courses may be valued in some places, others, different courses such as criminal procedure, ethics, or family law might be just as valuable. Also, many of the jurisdictions that have a PTLS program, we are alone in the specific course requirement. Additionally, this requirement envisions a program that's only applicable to someone in a traditional law school, and we are unsure of how it would be applied to someone in the LOS program since we are opening up. Finally, those administering the PTLS program, law offices, law schools, and so forth, they are free to create their own program requirements for the students who apply to work for them, and they may choose to accept only those students who have taken a certain course or studied specific areas of law. So by eliminating the regulatory requirement for specific coursework, we're opening up the program to more students and allowing the offices where the students work to tailor the requirements to their needs. Okay. And are there any questions?
Any questions on this last piece? I don't see any. Thank you for the comprehensive and very quick report. I appreciate that and all the work that's gone into this. Thank you to the members of the public who provided written comments that informed the recommendations from the staff. If I could see the resolutions up on the screen, that would be great. Quite a bit of stuff there. We do note that the reference to the attachments, which will be presented in a different way moving forward. Any debate, discussion, or questions? Seeing none, may I have a motion?
I'd make a motion.
We have a motion by Trustee Knoll.
Second.
We have a second by Trustee Shelby. Can I have the roll, please?
Broughton,
I think you're on mute, Mark.
Aye.
Ventura,
Aye.
Chen, not present. Cisneros,
Aye.
Good,
Aye.
Knoll,
Aye.
Shelby, Soel,
Aye.
Stallings,
Aye.
Tony,
Aye.
Duran.
Aye.
10 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. Item 706 is a request to recirculate for public comment proposed amendments to admissions rules related to testing accommodations. Those are rules 4.80 through 92. Ms. Dole. We're ready when you are.
Thank you. I believe everyone can see my screen.
Yep.
Yep.
Okay. Let's advance a couple of slides. So the State Bar developed a framework to streamline the testing accommodations process, relying on proof of past testing accommodations received on high stakes exam and limiting documentation needed. This framework was sent out for public comment and received 109 comments, 78 disagreeing with parts of the proposal, 15 agreeing with the proposal, and 14 agreeing if modified. The board actually received substantial public comments with this agenda item. However, I just wanted to call out the fact that these, well, with the exception of 2 pages, these comments have been previously provided to the Committee of Bar Examiners and attached to the agenda item. But based on these public comments, significant modifications were made to the proposed rules, including broadening the approval process. So how were these rules modified after the public comment? The framework was eliminated and the amended rules include the concepts from the framework, including the automatic approval process and the deference given to an applicant's qualified professional. In response to public comments, the appeal process or the request for review process is being reverted back to the Committee of Bar Examiners with a limit on 1 appeal per exam cycle. And then there was considerable discussion among the committee members whether accommodations approved for college or law school for timed exams should be included in the automatic approval process. Ultimately, the committee recommends giving greater deference to college and law school timed exams than originally proposed. That is the presentation, but I'm happy to answer any questions if there are any.
Thank you, Ms. Dole. Any questions? I do not see any. Mr. Tony.
I want to ask after the presentation. I can't tell if it's done or if
The presentation's done. Yep.
Can I just ask maybe our general counsel, we talked about this issue of a timeline for review of the request. I didn't hear that referenced.
Is it working? Okay, rules, the proposed rules do include a timeline for review of the applications. There is a 30-day review period for advising the applicant as to the completeness or if they need additional information about the testing accommodation. And then within 60 days of staff determining that there is complete information, they are to render a decision within 60 days. It's my understanding, and I think Christina will be able to supplement this further, that the plan is to develop more precise timeline as this process gets underway, because this is a new process. And so there might be additional timelines within those already articulated in the rules that would give a clearer picture as to how long a certain type of application might take to be reviewed by staff.
Okay, but you don't think anything further is needed, either in the rule or internal policy?
I don't think so. The ADA rules do not require a specific time frame to be included.
All right, thank you.
Thank you for the clarification. Mr. Tony.
There's an issue in which I have quite a few questions. I'll start with the basic ones, which is, well, first of all, I really appreciate that there were so many comments submitted, both from, and so many with people sharing their personal experiences. And so I want to ask about, one of the big requests was a 2-week response to accommodation requests. And I know that General Counsel Dovton has already started, I think, responding to that. But I'm kind of wondering what it is about this request that you think is reasonable or not reasonable, and is it something we can do?
So I'm going to answer the question, and if council wants to join in, they can. So I'm sorry, can you hear me?
Thank you.
Yes,
we
okay.
can. Yeah, go
Thank
ahead.
you. At the Committee of Bar Examiners, there was a lot of discussion around this topic as well. And the Committee of Bar Examiners made a motion that once we implement this new process, this streamlined process, we will have a better idea of how quickly we can go and review through all of the applicant files that are submitting requests for testing accommodations. So right now we have a 60-day timeline that's currently in our rules, but that's the outer boundary of that timeline. Once we implement this new streamlined framework, we do anticipate that we are going to be able to process the files faster. We're just not ready to say how fast that is going to be right now.
Thank you. Could you tell me a little bit more about what the current proposal, and I know that we're talking about sending it back out. What about what's the amount of time that candidates are going to be allowed to seek review once they get a determination back and they may want it reviewed?
So our current review rules right now have 10 days. That was our previous process. In these new modified rules, we're extending the request for additional information or a request for an applicant to say whether they'd like to appeal to 14 days at this point. So the rules that are going out for public comment now allow an applicant 14 days after a decision is made on the initial request to seek review.
Okay. And why is it you thought 14 was better than the 30 days requested in so many of the public comments?
So that really ties to our deadlines. So currently our appeal deadline is set, let's say for the July exam, since that's the one coming up, is set for the 1st of July, which is less than 24 days before the exam. So we wouldn't be able to give 30 days for an appeal because that would be after the exam is already administered. We do give the 2 weeks. We thought at least extending it by the 4 days would give applicants enough time to just let us know if they do plan on appealing as they collect their documents that they want to submit in addition to support that appeal.
Okay. Thank you very much. I'm going to have when this does come back from second round of comment, I would, like some additional work on fiscal impact, because I think that some of these may or may not have an impact, but it'd be nice to know what it is and what's it related to. I have a topic about a comment, and if it's okay, Mr. Chair, I've asked the Secretary of Staff to put up one of the comments on the screen. Is that okay with you?
I've got no objection, sure.
Okay. It's the so this is on page 420 of the comments that we received Wednesday afternoon. And I I feel pretty strongly that unless there is a very good reason, as in it violates our public comment um, uh, rules, that there's no reason to censor the comments that we receive. And so I would appreciate that unless it, the language is, racist or harassing, or we've got a whole number of categories in our public comment and from my understanding, this does not fall under that. So I just would appreciate that we get the comments as they are. There was one other redaction, which when I inquired about it, was an issue of someone who actually said something but said they didn't want it to be public. So that I understand. And, I'm not an absolutist on this, but to me, this is just basic free speech issue that I kind of believe in. So that's my only other comment for now.
Thank you, Trustee Tony. Any other questions or comments from the trustees? Seeing none, may I have the resolution on the screen? It's the 45-day recirculation period as presented by staff. Can I have a motion on this, please? I will move the item.
Second.
That was a second from Noel. May I have a roll call, please?
Broughton,
Yes.
Buenaventura,
Aye.
Chen, not present, Cisneros, okay, Good,
Aye.
Noel,
Aye.
Shelby, Soel,
Aye.
Stallings,
Aye.
Tony,
Aye.
Duran.
Aye.
9 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. Thank you, Ms. Dole. We'll move on to item 708, which is to discuss and approve an agreement regarding the California Department of Justice's investigation of state bar whistleblower and whistleblower retaliation complaints.
I think you skipped 707.
I did request skip 707. I'm not sure why I apologize. Okay. Item 707 is discussion and adoption of additional legislative priorities. This item is being presented by Bridget Grammy, Deputy Chief of Programs. Welcome back.
Okay, thank you. Louisa, do you have the slides on this? Okay. So this item, and I'm pinch hitting for Donna here on a few, so if you can bear with me. This item presents two sets of legislative priorities that we wanted to discuss today. So one has to do particularly with a path forward to demonstrate the bar's commitment to transparency and accountability, and really demonstrating to the legislature and to the public to help restore its confidence in us in light of the issues that came up with respect to Attorney Tom Girardi. And then we also have a couple of other what we call operational legislative priorities that we want to propose that would supplement the list that the board has already adopted in January. Let's see. Okay, so this first one, these are the key components that would comprise this path forward, and I'm going to go through each of those individually. So I also wanted to mention that these recommendations for a path forward for improvement have come largely from the Ad Hoc Committee on Oversight and Accountability, and so that's where these recommendations have come from. So the first one has to do with an inspector general or a discipline monitor for the discipline system. As part of its self-reflection on whether the board is currently organized and is currently well-positioned to meet its mandate to exercise effective oversight over the discipline system, the ad hoc committee and the board have explored different models for oversight. So you might remember at prior meetings you heard from the Inspector General over the prison systems, the Office of Ethics, Compliance, and Audit Services at the UC system. And so those are some of the models that we are exploring. So here, this is something that the Ad Hoc Commission was recommending that we could recommend as a legislative priority to the legislature that would help us and to assist in overseeing the discipline system. The Ad Hoc Committee did recommend that this position be report directly to the board. And we've since heard some feedback about this, about whether or not there would be a perception from stakeholders that this position wasn't sufficiently independent. And so it could be, we have up here as a decision point for the board, whether it makes sense for a recommendation on a legislative priority if this Inspector General should report to the board, or whether we might want to suggest that it report directly to the Supreme Court. So I don't know if you want me to go through everything, or do you want to talk
But
one at a
I
time?
think, Bridget, I don't think we were anticipating the board was going to decide this today.
Okay.
I think the item actually suggests that we just
think about it.
The board takes action. Yes, we want to establish this position, and based on further dialogue, figure out where it should be housed.
Okay, thank you for that. Okay. So then I will, unless anyone has questions about this, I'll just continue on with the
Let's
list.
check. Trustees, any questions on this initial piece? Trustee Sewell.
I'm not sure I have a question, but I wasn't, Leah, I don't think I heard you clearly. And so I just wanted to make, I do have a comment about this particular item. But are we just sort of discussing and not taking action? Is that what I heard?
Yeah, I think I'm just looking at the agenda item. I just don't think today we're asking the board to make a decision about Supreme Court or board as a matter of legislative priorities, because what we say in the item is we've begun this discussion, and it seems like more discussion is to be had with stakeholders about this position, where it should be housed. So that's all I was kind of clarifying, Arnie, that I don't think we necessarily calling the question today. I don't think enough conversation has happened with stakeholders, either legislative or the Supreme Court.
I agree with you, Leah. I don't think we need to take action now. What I would offer, though, is that I don't necessarily know it needs to be either or. I would suggest that maybe there is a panel of appointing authorities that this position report to. So it would be a legislative representative, a Supreme Court representative, a state bar, or representative potentially, and possibly even a gubernatorial representative. That so everybody has some stake in the game here, as opposed to it's either the Supreme Court or the bar. But as you mentioned, further discussion with stakeholders and others needs to be had. But that would just be a thought and a suggestion I might have.
I agree, Trustee Sewell. That is worthy of conversation for sure. That particular proposal with that configuration, I like that.
Okay, so as far as the adoption of the priority itself, it would be the board would be recommending an Inspector General or a discipline monitor as the priority, and then we can have further discussion with stakeholders about what we would be recommending as far as the reporting.
I believe that's where we're left. Yes.
Okay.
Anybody disagree? Just double check it.
The resolution reads that way now.
Okay, great. Okay. So the next section here is on strengthening the conflict of interest requirements. So as the board knows, the bar has been working to strengthen its conflict of interest procedures. The effort started before the May report's revelation of incredibly troubling conflict issues that touch staff leadership and the board members. And so what this item recommends as a priority is that we would be aligning our current practices really with what is in the Political Reform Act and the government code about non-financial conflicts when it comes to contracts. And so even though we don't necessarily need a statutory change for this, we think it would send a really important message that we are committed to doing this. So we would be clarifying the Political Reform Act, and then also, I believe part of this recommendation would be to increase the enforcement, or to recommend more enforcement on FPPC side over the state bar. Is that right, Aline?
Sure, I'm happy to step in. Currently, the state bar is exempt from the Political Reform Act's provisions relating to conflicts. There are portions of the Form 700 and Conflict of Interest Code that appear to apply to us, but not the remainder. So legislative amendment would be required to bring us into the purview and subject to the Political Reform Act. And staff is recommending pursuing that pathway. Just OGC is still conducting a little bit more of analysis to address what particular areas may pose concern to us. One area that may be troublesome is not troublesome, but that we need to approach more carefully is the revolving door provisions under the Political Reform Act and what type of impact it might have on our lower level staff. But overall, we're supportive of an amendment that would have the Political Reform Act apply to us. The other area is sort of alignment with the common law conflicts rules. And as the board is aware, the Business and Professions Code sections include specific conflicts provisions that apply to the state bar, Board of Trustees, and certain Form 700 filers for the state bar. And when it comes to non-financial personal interest, there is requirement that the interest actually will affect the decision, and it is more common in the area and more consistent with the common law to say may impact that interest. So we will pursue that type of a legislative amendment. I think that covers all of that. Thank you, Bridget.
Thank you. Okay, any questions on that one?
Don't see any questions. Keep
Okay. Okay, the next part has to do with the state bar's participation in the state budget process. This is something we've discussed here with the board. We've heard some legislative support for that over the years, and it's also something that the Legislative Analyst's Office recommended. And so the